Good morning. Law nerds. It's almost afternoon, but time is a construct. Nothing is real. I don't know what's happening. We're going to talk about court. It's Tuesday. It's January 6th. It's 2026. It's a very Monday, Tuesday for everyone who is trying to get their brains back into work. I don't even know. It's been all of the things over break. So Travis was sick. I was sick. I was like, God, I wish I knew what was going on in the world. And then I was like, gosh, I wish I knew less about what was going on in the world. I'm going to go back to binge watching Korean dramas on Netflix and watching Kim Kardashian not pass the bar because I was laid out for like 2 weeks. I'm still not all the way feeling better just yet. I was just like, yep. For any of you who are just like, why do I still feel sick? I don't know. But just out. Just everyone was sick. But I probably needed some rest, and I definitely got some cuddle time on the couch. And Griffin this break decided that he wanted to watch Stranger Things. He's never watched it, so we started Stranger Things with the entire family from the beginning, which only got complicated when Travis had plans because then we had to wait because you can't not have everyone together. So then we have been watching that as a family, which has been lovely and a lot of fun. No, we have not seen the finale yet. We are still a season behind, so hang out. All of you are asking, what have I been watching? I recently have been watching Bon Appetit, Your Majesty. I will talk about it when we get to Q&A. I'm obsessed. I love it. And now, like, there's not a lot of episodes left, so I'm trying to, like, I want to see, I'm going to have to just start rewatching it. I want to see what's happening. I don't want to finish the season. I love it so much. And for those of you that like a good K-drama, it's so much fun. It's cooking competition meets time travel, meets, like, slow burn love interest. It's delightful. My only tip is it is dubbed. The subtitles are better. I know this is a thing. This is always a thing. The subtitles are better. So I've been going through it with the subtitles. I find myself reading them. It's just so good. It's so fun. It's easy. And it's cooking. And it's just delightful to just be transported in the time traveling ridiculousness of it ever. It's just so lovely. So Bon Appetit is just so fun. It's fun. And that's what we needed when I was homesick. Also, the episodes are quite long. And there's times I actually laugh out loud. Just laugh out loud. Love. So I've got coffee. I've been watching it on Netflix. I don't know if it's elsewhere, but I've been watching it on Netflix. So let us talk about what we're going to talk about today. We'll get to Q&A later, because we'll get to Q&A and we'll talk about all the things, but we've got a lot to talk about today. My in-ears are pulling on my hair. We've got a lot to talk about today, but like not how I was expecting it to go. So this morning has already been a scramble, and you guys know what we do over winter break, right? I go like this. Okay, I need to replace like a one thing. It's the end of the year. We look at where we're at. What do we need technology-wise for the next year? Where are we at with what we need to do for the year? And so one of the things I really wanted to make sure is we didn't end up with a case again where we were going to be scrambling on closed captioning, which means I basically turned my studio into more of a TV studio. So that required a second computer. Because reasons. On members only, if you would like the entire details of how this went down, I'll tell you, because we're probably going to have 2 this month. So new computer. But then, because last break, I changed the desk setup, and then things were still shuffling around. So then it's like, well, if I'm already taking apart the computer setup, I might as well clean everything. Like take the rug out, clean everything, because it's been a year since I've like actually pulled the rug up and cleaned the floors and whatever. So we should just clean everything. And then as I was taking care of the rug, I'm like, I kind of hate this rug. So then I needed a new rug. So then it just ADHD'd. And then it went, and then. However, you'll see a little snippet of the new rug in the back here, in the background. Then we needed to undo the Christmas decorations, and then. And so now we are very well into the most minimal amount of cables that we have and like full cord management. But the cord management was going to be like the first part. And now we have a new rug. And do you know what happened when we got home? We got home. We got the rug in the office. Travis came in and was helping me vacuum new rug. And then he was walking on it. He's like, this is probably the best rug in our house. And then Dr. B came in and Dr. B's like, this is 100% the best rug in our house. And then we went through the other places where there's hardwood and went, all of our rugs suck. We need new rugs. So that's what we'll be doing this weekend. We did not use a gift card to buy the rug. We did head to the new, there's a Pottery Barn outlet near where we live. And so this rug was like outlet discounted and then like 50% off on top of that. So I was very excited. So you'll see a little snippet of the rug down here on the hardwood by the chair, but it's hoogly and cozy and lovely. So I love it. And now Dr. B is like, we need new rugs. Because when we moved, we had, planned on getting the boys who are also 5, not my children, the cats. And so we had new house, new cats. And we were just like, we're going to just get rugs that if they just need to be, if they do not last, they do not last. We did not want to deeply invest into rugs. So now we're just like, but no, there was no return card involved. No return card involved. So we're going to, Dr. B was very helpful digging through outlet shopping to find the correct rug. As I patiently touched every single rug. It was fantastic. So it's now on the list that we need a few other rugs in the house. So new rug, love it. New computer, working on new cables. The whole situation. Reset the desk a little bit, like where the monitor is, moved it around. You guys can't see that end, but I'll share pictures in the Leonard Lounge. Let's talk about what we're going to do today real quick, and then we're going to roll the intro. Yeah? Yeah? Mm-hmm. Yeah. All right. So, Kouri Richins. Kouri Richins was in court last week and a couple of weeks before that as well. This case is getting ready for trial, and the filings, we're now over like 1,300 filings in this case. It is really very much in the, you get to the precipice of like a roller coaster and then you're on the big drop. This is on the big drop to trial before it goes into like loops and turns and all the rest of it. So we are now in the big drop towards trial where everything is getting filed. All the motions in limine, the motions to exclude. We still don't know about the walk the dog letter. And if the Kouri Richins case is not familiar to you and the walk the dog letter is not, she is the Utah woman accused of poisoning her husband. She's also charged with the attempted murder of her husband on Valentine's Day, just 10 days-ish before he passed away in early March. And this case has been delayed a few times. Lawyers have been changed. The lawyers in this case, if you are watching other cases that are going on in Utah, you will have seen them there because they are also the appointed counsel for Tyler Robinson, which is something I have not covered, but I have kept an eye on because Utah courts and media access in Utah courts is its own special little funk. So it has been difficult covering things in this case because the court is like absolutely no streaming. But the judge is so delightful. He's just so delightful. Why don't you want to be streamed, Your Honor? You're so lovely. And there are a lot of outstanding evidentiary issues that are going to be determined over the next few days, January 7th and 8th. The court has said very clearly no streaming of those hearings. So the rest of my day today will be reaching out to whomever has been appointed pool counsel, because it's like a grab bag of whoever is pool media, and seeing what coverage is going to look like of those hearings. But it's going to be on delay in some way, which is fine because I don't imagine the rulings will be immediate. And what I have found from all the things in the Richins case is that even if the rulings aren't immediate, we learn quite a lot from the hearings. And that's what we're going to do today. We are going to cover the hearing from last week. And then there are some orders that the court has made that we are going to cover. And then I'll talk about generally what's outstanding for the motions in limine, motions regarding experts, etc. So when Kouri Richins goes to trial, the court has set aside 3 weeks for jury selection. So we will be covering other things when the jury selection starts and then keeping an eye on it. The judges also said no court on Friday. A lot of you are asking, Jolene included, will the trial be streamed? We don't know yet. We don't know if we will be a day delay, multiple days delay. We don't know. No idea. I'm hoping to find out. I'm optimistic. That once the court is done with jury selection, the court will lift the no streaming. The court has said multiple times, my concern is what information potential jurors may have. My logic says once the jurors are seated, then that's not a concern. Even if it's on like a 2-hour delay, that's fine. We'll figure it out. Your Honor, we'll be responsible, I promise. We love you. We love you. So with that, Brond in the chat asked, Emily, how wasn't it murder if he passed 10 days later? There was, I don't know why my chat wouldn't pull up. That's not helpful. Miguelina just has a note. There we go. It's back. 2026. It's fantastic. If year 2026 has felt bumpy, you're right with me. How wasn't it? She's charged with the murder in March and she's charged with the attempted murder in February. So she's charged with both and a bunch of other stuff. She's charged with a whole bunch of stuff. So we're going to go through some of that today. But as this case is getting ready to trial or go to trial, we start to see more about the case from the motions in limine. And the judge has allowed them to file anything that they feel vibes should be sealed under seal. So the docket is just sealed, 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 order for sealing, sealed, 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 sealed. There is a second case that was filed against her because the judge separated out, he bifurcated this case or severed the case early on, taking out some of the older financial fraud and mortgage fraud components. And the prosecution is asking the judge to reconsider those. That'll be heard over the next 2 days. So as we get into this case, how much about the financial fraud will be let in, we'll see. It's not going to be like Murdaugh. We are not going to have a whole mini trial on financial fraud, but it is part of the judge's consideration that the jury needs to consider what was going on, all of the circumstances that were going on with Kouri Richins before her husband passed, because the prosecution is really talking about financial motive here. Now, Kouri Richins did also have a boyfriend, a Sancho, a side piece, or as the prosecution in this case calls him, a paramour, not the band. So Kouri Richins was also with someone else and was telling that someone else that, she would be clear of her marriage within a few days. And that was just right before the murder. And on Valentine's Day, when Eric Richins got incredibly ill after eating a breakfast sandwich that she had picked up for him, she said she was installing cabinets at a house that she was flipping when really she was with her side piece. So there was also an affair happening on Kouri's end. So it was a lot going on, and the financial motives, I think, are fairly strong. It's very Murdaugh, but with an affair. So it's a very interesting case. If you are new to the Kouri Richins case, We will be in trial, I think, most of March and into the beginning of April with this case. I think we're going to have Fridays off. And we're going to be in Utah in a very similar looking courtroom to the one that the Gwyneth Paltrow case was in. I don't know if all the courtrooms in the building look the same or if it's the exact same one. I'm not sure. So, are you ready? We're going to roll the intro. We're going to go to court. We're going to read some motions. We're going to answer some questions. I see a lot of you asking me to cover something else later, guys. Not today. Not today. I know a lot of you are asking about the Karen Read sidebars. Look, we were planning on being in court for Karen Read today, so I was going to cover them later in the week. But I've got to figure out how we're going to cover the rest of the Richins hearings. But don't worry, they're on the list. They're on the list, not today. We're gonna go to Judge Beard today. But it's on my list. I'm not going to leave you hanging. It's a lot of an undertaking. And I can't read that much because I have been sick for 2 weeks. It's going to be a lot. But don't worry, we'll get there. All right, you guys, let's roll the intro. What a start to 2026. Law Nerds, I missed you. I hope you had a good break. I hope you weren't all just sick and in the thick of it the entire break. But if you were, I hope you are recovering well. All right, are you ready? Okay, let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. You guys ready to go to court? I know you're ready to go to sidebars. Not today. We'll get to the sidebar. Don't worry. I promise that we will. Let's see how court works. Oh, look at that. We've got Zoom court. Oh, wait, I've got to tell you guys a story real quick about this case. Did I already tell you this story? I don't know if I did. But we were heading to Chattanooga to watch state championships for football for my teens' high school. The last time that this case was before the judge, and it was a date setting, and we talked about that in the podcast afterwards. But I wanted to listen in on the call while we were driving to Chattanooga. So I put it on in the car. So Dr. B, I'm like, sorry, we're also gonna have to listen to court. And Dr. B's like, yeah, it's fine. So at the end of it, Dr. B is like, wait, is this the judge that y'all talk about his voice? I'm like, this is the one. He's like, oh. And I was like, Dr. B's like, I get it. I'm like, we all get it. So Dr. B was like, which case is this again? I was like, the one where she poisoned her husband allegedly. And he's like, oh, that one. I'm like, and the Docket 214 walk the dog letter and trying to smuggle in Crest white strips. And he was like, the white strips. The Crest white strips. That's where Dr. B remembered this case. Let me know how the audio is, because who knows what's happening today. And double check. We should have audio. Good.
All right, good afternoon. We're on the record in 231-500-139.
Hi, Your Honor.
State of Utah versus Kouri Richins.
I love that the prosecution's all just sitting in the empty courtroom and Mr. Ramos is in like, what room is this that Mr. Ramos is in? Don't dox Mr. Ramos. But defense attorney Ramos with the glorious window and the brick. I love it.
Can I have counsel for the state make their appearances, please?
Love it.
Your Honor, Brad Bloodworth, Lindsay Shervinack, Margaret Olson, Fred Burmester, and Joe Hill on behalf of the state.
Very good.
Y'all have been adding to that prosecution team, haven't you? And yes, for anyone new to this case, the prosecutor's name is Brad Bloodworth. Yes, that's real.
Good. On behalf of Ms. Richins, please.
Sorry, Mr. Ramos.
Wendy Lewis, Catherine Nestor, and Alexander Ramos on behalf of Ms. Richins.
Ms. Richins is present by WebEx. We're here for a brief pretrial conference in advance of the hearings that are set for next week. Mr. Bloodworth, from the state's perspective, are we on track as planned for January 7 and 8?
Yes, Your Honor, but I do have a few questions.
They are doing 2 full days of hearing, January 7th and 8th. And we are going to watch those probably in delay, at least a day in delay.
Has the court at this point identified any witnesses it would like to hear from on the 8th?
No, unless one of you specifically asks for an opportunity to voir dire a witness live in advance of trial, I'll make decisions either based upon just the papers that have been submitted or a combination of the briefs and your oral argument.
Sounds good. That works for me, Your Honor.
Okay, it was my understanding,
Nobody
this is
asked.
incorrect, that we were going to hear testimony from Molly Amon and Brittany Fox on the profiling issue.
I think that's on set. It was unclear to me whether we'd be doing that by live testimony or by declaration, but that would occur on the 7th, right, as part of the 702 issues.
Okay. And we had agreed that those witnesses could appear via WebEx. So,
I imagine we're going to see a lot of them.
Unless the court
via
doesn't find it
WebEx.
helpful. I mean, I think it would be helpful to hear from those witnesses. We're questioning the scientific methodology of.
I appreciate that Mr. Ramos is peeking out, but I am also covering up logos so that I don't have logo issues. So even if I moved, there was a giant logo directly under where I'm at. So that's where we're at.
That particular
Zoom
witness.
hearings.
I find it helpful to the extent you believe it's necessary to develop defendants'
I'm not gonna tell
arguments
you
in
what to
support
do.
of your motion to exclude under 702. If you don't think live testimony is necessary for the court to understand and rule on those arguments, then I'm not going to independently question those witnesses.
Yeah, y'all have to decide on your own.
Okay.
It's your case.
Your Honor, back
We
to
also probably
January
won't
8th.
hear from
Yep.
Mr. Ramos.
Well, may
'cause
we
he's not
stop
lead
just for a
counsel.
moment on those two witnesses? As the defense told the state that they want you to have those two people available to be questioned on January 7th.
They will be here via WebEx.
Got it. Okay. Sounds like everybody's options are preserved.
Your rights are preserved. The Lawners have your rights
Amon
are
and Fox.
preserved. Trauma, Your Honor.
Well, Amon is ours, Fox is there.
And Fox is ours. Yeah.
Yeah. Okay.
Right.
Yep.
Yep.
Your Honor, did the court on January the 8th want to address the motion regarding Greg White's subpoena, Maria Bramwell's subpoena, and the motion to appoint counsel for Lisa Darden?
No, I'm hoping to rule on all of those.
Lisa Darden is Kouri Richins' mother. What motion's about Lisa Darden, Mr. Bloodworth? Excuse me?
Subpoena, Maria Bramwell's subpoena, and the motion to appoint counsel for Lisa Darden.
The motion to appoint counsel for Lisa Darden. Now, we have talked about the defendant's mother in a few contexts because, okay, there are numerous lawsuits relating to this case in the estate of the victim. And we have gone over those ages ago. And in the estate civil cases, there's a lot of fighting over where money is, where money went, where marital funds went, whether money needs to be clawed back in to the estate, etc. We have well and done a lot of conversation about the estate. In that, there are some allegations that Kouri Richins had taken money from marital assets and kind of funneled them towards her mother for the house that her mom was living in, etc., and that those should be clawed back in. So the estate is saying we need money back from the mother. Kouri has 2 criminal cases, the attempted murder case and then the financial fraud case with the mortgage fraud and the rest of it. There are references to her mom in there as well as somewhere that money went. Her mom is not a co-defendant. Her mom is not involved in that way. However, there's also in the criminal case the walk the dog letter, which was written to Kouri's mother, telling Kouri's mother, it seemed to me, this is my interpretation, that Kouri's mother needed to tell the brother all of this strategy and stuff. So and the prosecution in that was alleging that this might have been witness tampering. And so if Kouri's mother is going to be called to testify or subpoenaed to testify, there is still this insinuation out there that perhaps she might have been involved in speaking to witnesses, or even if it's her son, because it was like, hey, mom, tell brother XYZ. Even if it's like, hey, tell brother, even if brother's on board with what mom's saying, that still could be interfering or dissuading witnesses. So there is an insinuation there that her mom was involved in the walk the dog letter, because the walk the dog letter, hold on, I didn't say it right.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
That one. Because what Kouri was doing, seemingly savvy enough, what Kouri was doing was writing out her letters and like holding them up to the screen on like the jail Zoom calls, thinking that if you don't say it, it's not recorded. So it seemed to me, was trying to get around the recorded call by writing a letter and holding it up. For any of you who don't know, Docket 214, we'll be talking more about the walk the dog letter later, but it was the holding it up to the screen. Now, her defense attorneys have argued that the mother never saw the letter, and that because the mother never saw the letter, it can't be witness intimidation because it was never conveyed to Kouri's mom to convey it to the brother. Kouri's mom obviously knows everything that's in the walk the dog letter because it's been all over the media and it's on the court docket. There is still an ongoing motion to as to whether or not the walk the dog letter will be admissible. So we'll be talking about that too. All right. That's the walk the dog letter. But that is, there are multiple contexts of how Kouri's mom factors in here. But I think because the prosecution insinuated that this walk the dog letter might be a problem, that I would suspect Kouri's mother is like, if I'm being subpoenaed, do I need a lawyer? The answer is yes, you probably do.
No, I'm hoping to rule on all of those in advance of January 7 on the papers.
You have it. They're not on the docket yet.
Candidly, had hoped to do that by now, but other cases got in the way.
I feel you, Your Honor. Candidly, I had hoped to spend 2 weeks like puttering and organizing and baking, and I did not.
Now, if I haven't seen the Bramwell law firm, Mr. White, ask for a hearing. Did I miss it?
I'm not aware of that.
Yeah. And so I think I can roll in the papers on those.
Yeah, if they're not asking for a hearing, you don't need to.
Okay, sir. There's an issue regarding the motion to appoint counsel for Lisa Darden
I saw that.
that I would like to address non-publicly today if we can.
You guys just got to give me a basis to do it.
Mr. Bloodworth, I really like you. I really do. But non-publicly? Dude, come on.
publicly. I just
That
have to
was
make
me.
some findings in order to close the record.
The court's like, I have to law. I have to do law. You got, like, non-publicly. Okay, but why though? But why though? Ugh.
Your Honor, it involves counsel in this case.
Okay.
Boy. It involves counsel in this case. Has counsel in this case been talking to Ms. Darden? Because remember, the last time we covered this, I was very curious about why Attorney Ramos, who is under the logo jail down here, I was very curious as to why Attorney Ramos had counsel appointed for him, and that's all sealed. We only saw the title of the motion. I moved the wrong thing. That was not fortuitous. I was trying to move me. I'm still getting used to new software. Look, man, Ramos. But Ramos had an attorney appointed, and we don't know why. That's all sealed. I just want to know. It involves counsel in this case. I don't doubt that Kouri Richins' mom is blowing up counsel in this case and trying to talk to them. I don't doubt that at all.
I'm inferring that discussion.
Counsel in this case is quite busy. Counsel in this case is very busy with other high-profile cases as well, and federal cases. But yeah, I'm sure.
Close the record.
Your Honor, it involves
Where are my Kouri Richins
counsel in
notes?
this case.
I can't even find my notes.
Okay.
Yeah, the Lawnards want the tea.
I'm inferring that discussion of what you want to discuss on the record in a public manner regarding that motion would materially prejudice defendant in advance of trial.
Do you hear the judge grabbing for legal basis? I am inferring. Okay, Your Honor.
It's possible. The thing is, at this point, I don't know.
Okay.
But I think if we were to have
That's
a quick
fair.
discussion today, non-publicly,
It's just annoying, but it's fair.
it could resolve itself.
Okay.
It could become a thing. I don't know.
We'll do that before we conclude today.
I think Mr. Bloodworth is being maybe overly cautious, saying it involves counsel and we need to have that conversation off of the public record, because it sounds like Mr. Bloodworth has questions but not answers and doesn't want to put those things out there publicly when he just doesn't know. I think he's being cautious.
Yes.
Okay.
It's fair.
Anything else on
But
your
I
list at
want
the
to
moment?
know.
Your Honor,
Are
confirmation
you going to let us stream, Your Honor?
regarding the deadline for defense Rule 16 disclosures.
Witness and
Go on.
disclosures.
I guess the state's question is it 2 weeks before February 10th jury selection or 2 weeks before February 23rd trial?
It's a fair clarification.
I mean, normally it would be before jury selection because that's when the trial starts.
And to some measure, the disclosures, particularly witness disclosures, may impact voir dire.
Right. It is,
That's fair.
Ms. Nestor, Ms. Lewis, is that possible?
I think that's what we were planning on. I think the last time we talked about it, the court had told us ours was due February 6th, maybe. But I guess that would not be 2 weeks before jury selection. Is that, so we're asking to make it sooner?
I don't know. I don't recall that, but that's entirely possible. My apologies. Tell me what your current plan is.
Currently, we were planning on producing on the 6th.
Your Honor, I would really like to stream this case. So could we do that? Could we just do that? Could we? Aaron, I have thought more about this than I should. Aaron said, I like how this judge has a shaved head and not even bald. I've thought about this probably more than I should. But this judge is also on one of the like avalanche emergency response committees in Utah. So I would guess ski helmets are much more comfortable. That would be my guess, because the judge is involved in a lot of outdoorsy things, which we found a couple hearings ago. And I was like, that's fascinating. I love it.
Of February, because I think that's when you had required it previously on the hearing when you set their disclosure date. If they need it, I mean, I think I could get it a week earlier if that would solve the problem. I don't think that's going to be a huge problem to get it a week earlier. But
Mr. Bloodworth, what does the state need?
Week earlier works, Your Honor.
Can we agree on, here, can we compromise on February 2nd in case they need the weekend to finalize some stuff?
Yes, sir.
Okay.
Did you hear what the judge just did? They were trying to pick a date, and then the judge was like, hey, can we just do February 2nd so the defense has the weekend to get it done? This judge, I just love the way he runs his court. He is incredibly considerate of the parties before his court, and the parties have really worked together well. The parties have, excuse me, the parties have agreed when they can. When they can't, they have done their jobs just fairly straightforward and well. I really like how this court is run. Shannon, that's a great question. I'm going to hold on to that until we get to the end of this hearing, but it's a great question. We'll get there.
Is Nestor February 2, please?
And that's for both witnesses and exhibits?
I'm getting yeses from the state.
yes, I've got that, Your Honor. We'll comply with that date.
Thank you. Mr. Bloodworth.
Your Honor, I think right now that's all I have.
Okay. All right. Ms. Nestor, Ms. Lewis, Mr. Ramos, are we on track for next week?
What do we got,
Week?
kids?
Yes. We were wondering, and this isn't really about next week, is there a date that we know we will have all
Are we on track for next week? Yes, and.
the jury questionnaires back? I know before you said no
That's
later than January 19th. Does that mean we may be getting them on January 19th, or could we get them possibly all by January 17th? When could we plan on seeing those?
Yeah, that's a timely question. Let me, I had some correspondence with the jury clerk that's managing that process. Let me give you an update. One moment.
I appreciate this judge. And yes, for any of you who are like, this hearing seems like a meeting to have a meeting, yes, because they have 2 days of hearings planned.
Okay,
Because they have 2 days of hearing planned, the judge is like, can we all just touch base and make sure that everything is kind of worked out? Sorry, Your Honor, that was a rude pause. So everything's worked out because this was last Friday, so January 2nd. Can we all just touch base and make sure that we're all on the same page before we set aside 2 full days of court on Wednesday and Thursday? Because then if anything needs to be dealt with, we can deal with it Monday, Tuesday, whatever. It just makes things go smoother and totally needed.
December 30th, 1,486 questionnaires had been completed. 340.
As of December 30th, 1,400 jury questionnaires had been completed. Wow.
Okay, as of December 30th, 1,486 questionnaires had been completed. 345 had been summoned but had not responded to the questionnaire. Those 345 were getting reminders to do so today with a deadline.
That would be me.
Well, they'll get a reminder either today or on Monday with a deadline to finish it by the end of next week.
That's a really good amount of prepared. Like, that's a lot of completed questionnaires. This is a really high number of questionnaires, but it is going to be like 3 weeks of jury selection and 4 or 5 weeks of trial in the winter. It's also a case that has garnered local interest. So it is, of the high profile cases we've covered, it is not the most high profile. However, with the Tyler Robinson prosecution, these 2 defense attorneys are also in the news. So people might also be paying attention to their other cases more because of that. And the defense attorneys went on a media interview not that long ago for local media. So the local media has been covering this pretty well. And it is a higher interest case. And the victim, it seems the victim and the defendant were quite well liked. But remember, when the defendant got arrested in May 2023, 2024, the defendant was on like a book tour for a children's book about grief that she had written. So the defendant was also in the media at the time that she was arrested. So this case has had many components, and, you know, the families were part of the local community. The victim owned a business in the local community. May of 2023 was that arrest. The victim owned a business. The defendant owned a business. Their families still live in the area. The kids are with the victim's family. So yeah, there's a lot of local. And so yes, that is a lot of questionnaires, but you're also going to find people that just can't be on jury duty for 3 or 4 weeks. And you're going to find people that know about the case. Lauren Bell asked, what happens if you don't comply with a jury questionnaire? It'd be the same as not appearing for being summoned, and different jurisdictions do different things for that. But it depends on the jurisdiction. Ultimately, some jurisdictions will go out and have the sheriffs knock on your door and have you come explain. Some jurisdictions won't renew your driver's license if you have failed to appear for jury duty. It really just depends. Really just depends.
I asked the jury clerk to send me the Excel spreadsheets on or about January 13. My plan would be to send it to all counsel on the 14th or 15th.
Oh, great.
Also, there are going to be some of those questionnaires. There's 345 that were summoned and not responded. It's reasonable that some of those went to a wrong address. That person no longer lives at that address. So some of them might also be that the person it was intended for just didn't get it. But that's a large amount of questionnaires completed. They'll be able to pick a jury with 1,400 questionnaires completed.
Thanks.
Bailey K in the chat said,
If I may, you
I
all.
thought the judge was pausing. As a local, everyone talks about this case and refers to it by the lady who killed her husband and wrote a children's book to make the kids feel better. Yeah. Yeah.
Have this firmly in hand, but if I may make a recommendation to avoid errors that I've made in the past, create a working copy of the Excel spreadsheet. One you treat as sacrosanct as the original. The other is the one you play with sorting in. If you make a mistake sorting.
Tell me how you play with your spreadsheets again, Your Honor. Hold on. Let me just back up.
In hand, but if I may make a recommendation to avoid errors that I've made in the past, create a working copy of the Excel spreadsheet. One you treat as sacrosanct as the original. The other is the one you play with sorting in. If you make a mistake sorting them, it's almost impossible to undo.
Good advice.
Don't fuck up the spreadsheet.
Okay,
Make a copy.
Keep going. What else do you have on your list?
Maddie, I can't imagine that, but they all know about the case because we talked about it on the airplane on the way to Vegas so much. So all the Real Housewives, well, no, not all the Real Housewives of Salt Lake City. I was talking mostly to Angie Meredith, not Meredith, Angie. My brain just absolutely stopped because I'm thinking about this judge. And where we're going next with how many jurors have responded. Angie, Heather, and Whitney about it. For those of you that missed that story, it was on the way to BravoCon. We'll circle back. I was just like, why? My brain just stopped because I was thinking, but Meredith is also an attorney. And so if she showed up, she'd be like, but I'm a lawyer. Excuse me, Your Honor. Is this more than rumors? And I think it would be very strange if Mary showed up on jury duty. Could you imagine in like a full length, like red coat? Bronwyn and I talked about this case too. Like, what would Bronwyn wear to jury duty? Emily, focus. Okay.
Don't think we have anything.
Ms. Nestor, anything else until we go into a closed session?
I don't want to go into a closed session.
I don't think so. I did want to just clarify as far as the jury instructions.
That's the Zoom, not you. If you're like, but voice and mouth, why not the same? It's the Zoom.
I was having trouble understanding my own notes. You wanted just basically like a little brief summary of our support of any instruction that we're asking for that is not agreed on, right?
Yeah,
This is about jury instructions.
it can be of varying amounts of substance. Sometimes it can just be simply a citation in the footer to the controlling case that says it was reversible error not to give the instruction, right? I can connect those dots. If it requires a few paragraphs of explanation, maybe put together a short brief saying, here's why we're entitled to this instruction.
The other question or just thing I needed to bring to the court's attention. So the state on a few days ago, and it's the holidays, and I'm sorry, but the days are all confusing to me.
Ma'am, during the holidays, the days don't exist. It's like, is it Tuesday? Is it Saturday? I don't even know. It's yes. When you are lucky enough to have time off over the holidays, they really merge together. When you have to work over the holidays but have certain days off, it gets real confusing, and then time's fake. Time kind of feels fake in courts. Time feels kind of fake between like the week before Thanksgiving and like mid-January. Everything is just like whatever.
Because they've all been in the middle of the week. But within the last week,
I feel that.
the state has amended their exhibit list to include approximately, 20 to 30 new exhibits. I
that's a
anticipate
lot.
that at least some of those exhibits I am going to have objections to in the form of a motion in limine. I will try to get something on paper this weekend as quickly as I can. I don't know if it would be in time to hear it on the 7th and 8th, but it might be something we need to take a few minutes on, prior to trial. I don't know. I know.
Motions in limine.
I imagine there will be
They'll have Fridays off. There
several
will be
of
time.
those between now and opening statements.
There will
Well,
be
and I
time.
assume they'll have some motions in limine on anything I want to introduce, which they won't even see until the 2nd. So I assume there will be one more round of motions in limine, but I am just giving the courts a heads up that I do anticipate objecting to at least a few.
There will always be more motions in limine. Metaphorical heart or metaphoric heart in the chat said not Karen Reed, is Kouri Richins. It's gonna take me till 2027 to get this right. Is Richins in the courtroom? No, she is appearing via WebEx from the custody. She was not transported to court because all of her attorneys are appearing remotely, and she's not shown on it. So she is present, but not on screen via Zoom WebEx video call.
Of those new exhibits.
Yeah, I appreciate that.
And some of them are going to fall under the same type of objection that I've already made in my motion in limine. So it may just be that we can just add those into the argument because it's the same nature of document on the argument we have on the 8th. But if that's stressful to the state and they'd rather argue it separately, we can. But I think some of them are going to just be connected.
Excuse me, ma'am. We don't start rumors on this channel, but Attorney Bloodworth is actually 753 years old, and he doesn't get stressed. So no, I don't think anything's going to be stressful for Mr. Bloodworth. I think he has got it handled.
The same type of objections I've already made.
I'm less concerned if it's stressful to the state and more concerned if it's stressful to me. There are
Right.
8 or more of you, and there's 1 of me. And
Right.
so
The judge is so real for that. I don't care if it's stressful to the state. There's a fucking fleet of attorneys for the state. He's like, there's one of me and I have to read everything. I feel you, Your Honor. There are 1,300 plus filings in this case. When I say I can't keep up with the dockets, I totally understand where the court's at, because look, my docket of cases I'm trying to keep up with is much lighter than the docket of cases this judge has to work with. And I don't have to make decisions about them. I just have to explain. Sometimes just read out loud. The hardest part sometimes is navigating the court's website to try to make sure we can get all the documents. But the amount of time it takes to read things in the way where you're going to rule on them is very different. Emily, how do you know how judges read things to rule on them? A, friends who are judges. B, I worked as a research attorney for judges early on in my career before I went to the district attorney's office. So I spent quite a lot of my time, all of my time, reading things that the judge would rule on, pulling the case law that the attorneys had cited, and making memos to the judges about what the attorneys were arguing, what it said, so that the judges had kind of the highlighted issues as they were going into it, and then would help them craft their rulings and what have you. So, and write those rulings and chat with them about what I had found, what they had found, what they were thinking. So I've done that work too. It's an incredible amount of information to process and a tremendous amount of reading, and like really in-depth reading, not like casual reading. It's quite a skill. And it's quite a lot of work. Yeah.
there are 8 or more of you, and there's 1 of me. And
Right.
so the limiting factor is my ability to be prepared, be able to make timely rulings and keep it all straight.
Yeah.
I would understand if the defense waited to see what came of the hearings on January 7th and 8th, and then both sides of the V fashioned future objections with the
Okay.
information of what we did on the 7th and 8th.
That's fair.
That makes good sense. We'll do it that way.
Does make good sense. That's why.
But
he's
I
the
just didn't
judge.
want you to think I was hiding in the weeds on it or anything. I do anticipate that coming.
I anticipate that this will be an iterative.
Yes, Leonards, I am with you. I also love the judge's like hand warmer mug situation. It's fabulous. Sorry, my house is making noises. Is it starting to rain? Maybe. I love the judge's fabulous mug, and I love that the judge is like, it's going to be an iterative process. Yes, it is going to be an iterative process.
But I just didn't want you to think I was hiding in the weeds on it or anything. I do anticipate that coming.
I anticipate that this will be an iterative process.
Yes. And also, I think I announced the last time we were before the court that I was planning on filing a Dauber challenge to the DEA drug expert.
Okay. You're going to file a Dauber motion, which is challenging the expertise about the DEA. Okay.
You're not going to file a Dauber motion on that one. So,
That's
I
fine.
didn't know if you were looking for that, or if you even remembered that I said it, but we're not going to proceed with that one.
The judge heard you say it and went,
Only consider and rule on what gets filed.
Yeah.
Okay.
I guess one other thing quickly is just to keep it straight, since there have been so many filings.
Yes, Ms.
from
Lewis.
our notes and perspective, I think the only thing that needs to have briefing completed before the 7th and 8th is I think we still need to file a reply motion to our motions in limine, which I believe is due Monday. If
you choose to,
right.
you're not required to.
Okay. And Brittany, I think one of our paralegals emailed you, but if there's anything else that's not fully briefed that we have let go.
Brittany is the judge's clerk. What are you asking the clerk for?
Anything else that's not fully briefed that we have let go. If that would be not too difficult to let us know.
Yeah, with respect, Brittany's not the person for that job. You all need to just.
Hey, Your Honor. I love it. I love it. That's not my clerk's job, ma'am. Did you hear what the defense asked? Attorney Lewis, and I get why Attorney Lewis is asking. Attorney Lewis asked if there's any motions that our briefing's not complete on. Brittany, can you just let us know? Brittany has to say nothing. And the court's like, excuse me? This isn't Brittany's job. That's not my clerk's job. That's your job. There are 10 of you. There is one of my clerk. You do not ask my clerk to do that. I am going to let you know, not all judges protect their court staff in this way. Good judges do. Most judges do. But not all judges do. But the lawyers don't get to assign work to the clerk. The clerk's got enough to do. It's an incredibly busy job. They don't have time to go through and be like, oh, yes, actually, you're missing a reply here and a reply there. No. God, I love it. The judge is like,
Just go through the docket and figure out if there's anything that you.
I'm going to rewind that. I appreciate, look, defense attorneys are going to defense attorneys. No points off for asking. I'm not surprised that the defense is like, could we just? And the court's like, yeah, no. But I appreciate that the judge is like, would you ever? I don't think I've ever seen a prosecutor even ask for something like that because they know that's not going to happen.
That we have let go. If that would be not too difficult to let us know.
Yeah, with respect,
Yeah, no.
Brittany's not the person for that job. You all need to just go through the docket and figure out if there's anything that you want to have submitted for decision that isn't yet. But we can't ask Brittany to do that for you.
Grab your paralegal, ma'am.
All right, understood. That's fine.
Somebody should have been
I thought
tracking
she
it.
might just know because she's Brittany, but
She might, but that's not her job to do that.
I love that she's like, if she just knows off the top of her head. The judge is like, nah, not her job.
Okay, Mr. Ramos, anything today, sir?
He shook
All
his
right.
head.
Let's see. The potential scope of testimony of Ms. Darden, Ms. Richins' mother, is a sensitive topic that may or may not.
Excuse me. Here's the tea. I appreciate the tea. The potential scope of Kouri Richins' mother's testimony.
Richins' mother is a sensitive topic that may or may not implicate Ms. Darden's Fifth Amendment rights, may implicate
Ding, ding, ding.
a proffer of testimony or other evidence that may or may not be admissible. That all has the potential to affect the jury pool this close to trial. It has the potential to affect the voir dire process. Out of an abundance of caution, the court finds it is necessary to
Counsel? What is? Oh, Zoom court. Counsel.
consider the motion to appoint counsel for Ms. Darden as a potential.
I also really like that style of Apple Watch bands too, counsel. I really do. I really like those.
Potential witness in a closed hearing in which the lawyers and the parties will be fully participating, but that will be sealed from public view or review. Ms.
Your Honor.
Nestor, any objection?
no objection.
I
But could we ask that our investigator, Chris Bertram, be allowed be brought into the meeting, please?
I
Yes.
object.
Anybody else?
Me.
No one else.
I think the
Object.
victim representative is entitled to be there. Should I add the Richins family?
Yes. That's very thoughtful, Your Honor.
All right. We will now go into that closed session via breakout room. Give me just a moment.
So I appreciate that the court is allowing the victim advocate and the
I
victim's
think
family
Kouri Richins-Benson is also on.
to be present in the breakout room so that they can hear, but it is sealed, which means transcripts of the rest of the hearing will not be available until it's unsealed, and the rest of the hearing will be outside of public view.
I
So
can't see her. I'm sorry.
anyone that was on
KRB.
anyone that was on the WebEx call would have been just left in the main room. They would have moved to the breakout rooms. We're going to see what happens. There's a few more minutes left of this, so I'm just going to let it
If you'd all
roll.
accept that, please.
Oh, well, I guess they're moving to the breakout room. All right, bye, everybody. And then the prosecution's just going to chill in court? Okay.
Pause. Okay. We need to take a pause for just 1 minute for a technical issue. We'll be right back.
Me this morning. I saw a couple of you ask, why is this remote? A, it was January 2nd. B, the defense attorneys work in multiple locations in the state. And so getting to court may have presented some timing challenges. And this was a check-in and scheduling. There's no real need for the defense to be present and to drive all the way down or up or over to the Park City courthouse. So it's not necessarily needed for this. It will be for the 7th and 8th for the hearings, but not, this is a logistics meeting. But there's stuff going on with the defendant's mom, and that's interesting to me. So let's see if anything else happens in court. It might not. It might. We'll see. So yeah, it's just logistics. And the technology allows them to, oh, everybody's back. Hold on. Wait, why did my screen freeze? I'm having technical difficulties. So that is, it's logistics, and it's actually helpful for the defense. They have lots of other cases all over the place. So my controls, give me 1 second. My controls just froze, so I can't even refresh my monitor to see why it stopped showing my monitor. So give me 1 second, because the monitor on screen is frozen, but the monitor in the office is not. So give me 1 moment. Today is going to be that kind of it's apparently just going to be that kind of a day. Yay. Okay, that worked better than anticipated. All right, let's go back to court. Oh, it's just yay for us. Streaming is dynamic. It's,
Okay, we're back on the record in an open proceeding 231-500-139.
Oh, I wonder if this is after the closed proceeding.
This concludes the proceedings today. We will reconvene next week on January 7 at 9:30 a.m. in person in Silver Summit. Counsel, I wish you and your clients the very best.
And all of you said, now there is an echo. That's odd. That's really odd. There shouldn't be. I have no idea why the echo. Sorry, chat. Hold on. Let's see if we can figure that out real quick, because there definitely shouldn't be an echo. And we did change some things. No, I don't need the devices in my office talking to me. We changed some things in our tech setup. So give me a second. Let me make sure that it's not on my end. The judge is just going to close the record because I don't have an echo. I don't have an echo in my ears. So, or at least I didn't think I did. All of you are saying it was on the Zoom.
Okay, we're back on the record in an open proceeding 231.
I didn't hear the echo from court. So give me 1 second and double check on cancel. Oh, because the device is, yes, device. Let me just check settings real quick on my end and make sure that I can figure out why you guys are getting double audio of the audio coming into the stream, because that is not helpful at all. And I do not hear it on my end, which means maybe it is a setting, because I don't have a Zoom echo. No, Chad, I understand, but I don't have a Zoom echo, which means it's coming from somewhere else. I just don't know where it's coming from. Let's see. And I don't know where that is coming from. All right. Well, it is, a lot of you are saying that you hear, we don't have any other audio for today. So I'm going to need to look at that on my end, but all of you were like, no, it's just coming on Zoom. I don't know why I don't hear it, but they're closing the session. They're back January 7th and 8th. Let's talk about what happened at this hearing, and let's go to some of the judges' rulings. Shall we? All right. Sounds good. Let's go. Let's go back to court. Well, let's leave court and summarize what happened in court, because it's just going to be that kind of a week, apparently. So at the hearing from January 2nd, 2026, which I am going to mess up for at least 6 months, because how is it 2026 already? I have no idea. But at the hearing from January 2nd, 2026, Kouri Richins and her attorneys were in court via WebEx. The prosecution was in court. The judge, of course, in court. And with that, the hearing was really to make sure that everyone was on the same page before going into 2 days of hearings on January 7th and January 8th. Over those 2 days of hearings, they are going to be dealing with some hearings regarding experts, hearings regarding evidence, the beginning of motions in limine. The court said to the attorneys, it is an iterative process, meaning it is going to take some different steps to get through. They are going to do the first round of motions in limine, and the prosecution has asked for evidentiary rulings on certain things, like the walk the dog letter that was recovered from Kouri Richins' jail cell, like a journal that was recovered in the search of Kouri Richins' house, and other things. So they're trying to get ahead of evidentiary rulings and have those argument before the jury's even selected. Those things can impact how jury selection goes, what's asked at jury selection, but it can also impact opening statements and really the order of the trial. So as much as they can, evidence that they know is going to be argued over or objected to, a lot of the time you can look at the arguments for it and start getting those rulings in early. With the Docket 214 letter, the defense has argued quite a lot of different ways why it should be kept out of evidence. And of course, the prosecution has argued many different ways it should be allowed into evidence. And it lays the groundwork in that walk the dog letter for some of the defendant's possible defenses. The defendant argued that, the defendant told her mother to tell her brother in the walk the dog letter, whether her mom saw it or not, we don't know, but said, hey, talk about the fact that the victim, in this case, Eric, had weed gummies or would get them from Mexico. And, maybe they were laced with fentanyl and maybe this and maybe that. So the arguments the defense is likely to make in trial are laid out by the defendant in this letter. And then if the defendant testifies, that letter is going to become even more necessary. As if the defendant's mother testifies and is like, yes, I know that the victim ingested this or could have done that. Well, this letter seems to say it was more of a plan than the truth. So when you're looking at something like the walk the dog letter, those evidentiary arguments can be made in advance. You know what's going to happen. Now, there's other things that, of course, are going to happen during trial on the fly, and that's why the judge reminded this is going to just part of it can happen in advance, but some of it's just going to happen once we get into trial. It can't all happen in advance. So on January 7th and 8th, there will be 2 days of hearings in the Kouri Richins case in Utah. The judge has again ordered no streaming. So how and when we will cover that? We will cover it. How and when we will cover it? Like live versus not live. I guess everything's going to be not in real time. Will be in the Law Nerd app. So if you are new to the Law Nerd community or new to this case, Law Nerd app at lawnerdapp.com. Notebook. Law Nerd app at lawnerdapp.com. And I will tell you, if we need to shift around when we're streaming to accommodate for those hearings, I will keep you posted in the Law Nerd app. It is a free iOS and Android download. We built it for you, and we're going to cover those hearings. It's just going to be a matter of when. I don't know if the judge is going to rule on everything on the bench. He does that often, but some of these things might be written rulings because they are going to impact the trial, especially when we look at things like the walk the dog letter. I'm interested to hear the arguments over the experts because the motions in limine really do give us a pretty broad view of what each side thinks the evidence will be. And I hope once this case gets ready for trial after jury selection, the judge changes his mind about no live streaming. But we won't know until we are closer to the end of February when this trial will start with evidence. So we'll just have to wait and see. So this one's going to be interesting. How are we going to cover it? As best we can. So get the Law Nerd app and we'll keep you in the post. We'll just have to be nimble, which is what happened today. Last night, I had very much prepped to cover Karen Reed stuff today, and the judge had the entire day. There was nothing else on calendar for the judge in the Karen Reed case today. The Karen Reed civil case had docketed a communication with the attorneys yesterday, like late in the day yesterday, and had asked all of the attorneys to reach out to the court and let them know who's going to be arguing. There's various discovery motions pending. And then this morning, all the attorneys were like, we're not ready yet. I'm like, the judge set aside an entire day. Like, as did I, but it doesn't matter. But the judge set aside a whole day. So this morning, when all of you got your alert in the app of me messaging you saying, hey guys, change of plan. We're going to have to shift gears. We're going to have to just shift gears and cover something different. So we will see. Kathy said the judge is allowing it to be streamed on delay. I'll have to go look. Kathy, if you could send me where you saw that. Because when I pulled the media order, it said in the notes specifically no streaming. So if he changed his media order, I'll reach out to the clerk today. But if he changed his media order, I would love to see that. That would be fantastic. And if he does it on a delay, we'll just stream it. We'll stream on delay as well. That would be great. So this is why I say just get the app. It's the best way for me to keep you in the loop. Because streaming is dynamic. It's just. Hello, awesome in the chat said, thank you for streaming today. Of course, we want to get back to our schedule too. Recovering from sinus surgery and playing mobile games. You're going to feel so much better after sinus surgery. Dr. B had sinus surgery. It was so good. It was so good for him. So I hope that you recover well, and it is so good too. Sinus stuff is the worst. It's just the worst. All right. Kelly B said, what is the difference for the court between live stream and playback? Will they edit stuff out? No, they don't edit stuff out. They just say you can't start at the time that we start. So I don't know how the court views it as different. I don't know how the court views it as different. If it's a 1 hour delay, 2 hour delay, streamed on a 10-second delay, I don't know. But no, they don't edit stuff out. It's just a continuous feed. It's just behind real time. And I wonder if the judge does that in case there is an issue and they need to stop the stream. I don't know. I don't know what the court's thought is on that. And maybe it is just that. Like if something happens, we can we can stop the feed, but the court wouldn't know something happened. Like in the rare time that they might have had issues where a juror might have been caught on stream or something, you don't know until you see it on feed. So even if you're behind, you don't really know. I don't know how judges make these decisions, but we delay anyway. So the only time to me that it really matters is when a verdict comes out. That's when it's difficult to avoid spoilers. Like once a verdict's out, it gets pretty difficult to avoid spoilers. But for the rest of it, I mean, the journey's really the thing. We want to see what happens, and we enjoy doing it. Well, I think we enjoy doing it together. I enjoy doing it together with all of you. So let's get to all of the different rulings that we have not covered yet. And then I'll keep you posted in the chat or in the app for how we're going to cover hearings and when we're going to cover Karen Read sidebars. We will. It's just not, this was coming up for hearing this week. So it was, if we weren't going to do the Karen Read civil case today, this took priority. We'll get to it. Don't worry. We got it. This one is rocketing towards trial. And I am so curious. There's so much in this case that we know, but there's so much in this case that we don't know. And I hate not knowing. When I look at a docket, let me see if I still have the docket pulled up. I do still have the docket pulled up. Let me show you this docket. When I look at a docket with this much that is freaking redacted, it makes my brain hurt. Because I want to know. I want to know. You want to know. We want to know. We just want to know. Hold on. Let me get to as I said, this docket, I have a touch mouse. This docket is so long. So long. I'm not there. I'm not there yet. All right. Here we go. Docket. Nope. We're still in the 1200s. There we go. When you go through this docket, you can see how much is labeled as private. It's private. So, private. Will those get unsealed later? Yes, those will get unsealed later. Are they unsealed now? No. So, private. All of it. All of you are like, we were scrolling so fast we can't read. No, I didn't anticipate. Oh, now I'm on the wrong screen. I didn't anticipate that you would read it. You can see the asterisks. It's all the asterisks. Because I also don't want to spoil anything that we're going to cover right now. So it's too much under seal. But the judge is very mindful of not wanting the jurors to have information on this case. The judge has made numerous comments about media coverage in this case, about things that have been covered that just aren't accurate in this case, the rest of it. So there's been quite a lot that has come out from the court on little like snippets of the judge's displeasure with some of the media coverage. And the judge, at the end of the day, is here to protect a fair trial for the defendant. So that's his goal. All right. The first ruling that I want to cover that I saw is docket number 1353. The judge made a ruling regarding Kouri Richins' mom. And we're going to take a look at that ruling first. So let's get to the judge's ruling there. This was the part of the hearing that was sealed from public view. So let's go take a look. See if the ruling gives us any hints. Emily, that's the wrong one. But let's see. There we go. That's the right one. This is from January 2nd, so this was after the hearing. Before the court is defendant's motion to appoint counsel for Lisa Darden. Well, that's different. That's different than just having counsel. They want counsel appointed by the state. Based on the parties' briefing and counsel's argument on the record during a closed session on January 2nd, the court rules as follows. Defendant's motion to appoint counsel for Lisa Darden is denied without prejudice as moot under the current circumstances. That gives us nothing. Oh my God, you'll have nothing and you'll like it. You give us nothing. Ugh. It's moot. Well, maybe she's not asking for a lawyer. Maybe she's not going to testify. Maybe she hired an attorney. It could be so many things. I mean, maybe she did. Maybe she hired her own attorney. That would probably be smart to hire an attorney. All right. Well, the order is moo. Fair. Kathy Mama Bear, thank you so much. I appreciate it. All right. Let's get to some of the other judges' orders that we have not covered yet. We did not cover the motion to compel, the order on that, the order regarding bail, because the defense had made an additional motion for Kouri Richins to be out on bail. But the prosecution also finally filed their reply to the motions regarding the walk the dog letter. The motion to exclude the walk the dog letter was literally filed years ago. And then there was an opposition file, or the prosecution filed the motion to deem it, as admissible. The defense filed an op, and this was literally years ago. And now the state has finally filed their reply on the walk the dog letter. I think this is one of those things that got just lost in the sauce. So we're going to take a look at what the reply is, because I hope, I haven't read it yet, we're going to read it together. I hope that Attorney Bloodworth gives us a little bit of a lay of the land there, for those of you asking. It is the new sparkly Laneige. I like their lip glosses quite a lot. We'll see how it goes on stream. Some get sticky when you talk a lot. Some don't. We'll see. It's new. All right. Should we talk about the walk the dog letter?
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
Yes, they do. Yes, they do. All right. State's reply in support of its motion to determine admissibility of the walk the dog letter. Statement of new matter. Is there new matter? The defendant's response to state's motion to determine the admissibility of the walk the dog letter overreaches legally and factually. Oh, Brad. As set forth in the motion, the first 3 pages of the walk the dog letter are admissible because the defendant's consciousness of guilt is relevant, more probative than unfairly prejudicial, and proves her intent, plan, and identity in causing Eric Richins' death. Argument rebutting new matter. Okay. We might have to go through the walk the dog letter again. Hold on. Let me just put up a poll. Yes, chat. For those of you new to this case, I don't think Attorney Bloodworth just pulled the word laundered out of his hat. I don't. I think he has a little bit of a laundered himself. Brad, it's okay. We love your sassy writing. You can be a Bloodworth. You can be a laundered, Mr. Bloodworth. Let's see. Let's put up a poll. I moved this monitor. We'll see how we like it. I think it's a little easier to see. but we'll see. All right. Poll is up for you guys in the chat. For replay crew, sorry, no poll. Get the Lawnerd app, and then you can be in the chat. The defendant's Rule 402 argument is legally unsupported and factually inaccurate. You're wrong. And also, you're wrong. Once more, you're wrong. The defendant asserts that the walk the dog letter is not relevant because, quote, statements made in a vacuum cannot possibly be relevant. That's just hyperbolic. Do I have the defense's opposition to this still? No, we can't do both. We can't go down that rabbit hole. All right. The defendant does not cite authority for this assertion because it is not true. Indeed, the defendant's consciousness of guilt is revealed in her writing of the walk the dog letter, not in anyone reading it. I mean, tell me what you guys think, law nerds. If Donna Adelson had written out the script for her bunkmates, and you didn't have the bunkmate coming in and saying she read it to me, and you just had the script, would that still be relevant to you in Donna Adelson's trial? As her writing a script to the bunkmate, would that still matter to you in what Donna was thinking about her trial, the evidence, her story, what happened? Because this is essentially the same thing. It's just, it is the script. The script is just to the family members. All of you in the chat are saying 100%. Yeah, this is just a script in a different context. Well, Adelson did it after, but it's the same. It still matters. Now, knowing that she sat down with someone might make that evidence way more prejudicial. You know, it might take a juror from, okay, well, maybe she was thinking about it and changed her mind. Maybe she was just journaling. She needed to just manifest that they would come in and say what she wanted them to say, and she didn't actually tell them. And maybe it was just a thought in one's mind. But when you have to determine consciousness of guilt, when you have to determine premeditation, when you have to determine a thought in someone's mind, the things they are writing helps you determine the thought in their mind. So yes, whether it's shown to someone or read to someone, it is still a thought in someone's mind. So continuing that one. The prosecution said the defendant's consciousness of guilt is revealed in her writing the walk the dog letter, not in anyone reading it. The walk the dog letter speaks for itself, as statements do all the time. It's res ipsa loquitur. The thing speaks for itself. And the consciousness of guilt it reveals tends to make it more likely that the defendant caused Eric Richins' death. Why do you need a story if the truth is the truth, then why do you need a story? Because that's just the truth. You don't need a story if the truth is the truth, right? Mm-hmm. It goes on to say, accordingly, as set forth in the motion, the walk the dog letter is relevant. Oh, I agree that the walk the dog letter is relevant. It says, moreover, contrary to the response, the walk the dog letter was not eternally locked in a vacuum. Rather, there is a strong inference that defendant intended to convey it to another individual. First, it is written to her mother. And they have a whole bunch of jail calls with her talking to her mom about all kinds of stuff. And if her mom testifies and her brother testifies, this might also be impeachment, but I digress. The prosecution says, first, it was written to her mother. The day before the authorities recovered the walk the dog letter from defendant's jail cell, she rehearsed sending letter number 2 to her mother using HomeWave's video feature to bypass the jail's normal mail screening. And then they cite where that is in the docket. Regardless, it simply does not matter that the authorities seized the letter before the defendant sent it to her mother. It was just an attempt to dissuade, but they're not charging her with that. They're using this for consciousness of guilt. I literally read the next thing as in State versus Boone or Sarah versus Boone. Emily, wrong case. In State versus Braun, the defendant wrote a letter during his murder trial that was intercepted by jail staff and subsequently introduced against him at trial. The defense objected to relevancy and argued that the quoted parts of the letter are vague and subject to more than one interpretation. That's what argument's for. The state offered the letter as, quote, relevant to establish an inference of defendant's consciousness of guilt. Well, right. Unless the defendant says, hi, it's me, I'm the problem, it's me, you have to infer consciousness of guilt from the surrounding circumstances. People make determinations all the time. Sometimes they're right, sometimes they're not. They go on to cite that case law saying that in the ruling on relevancy, the trial court found that the letter reasonably could be construed as an attempt to engage a fellow inmate to take action against a trial witness in order to stop him from testifying further. That's nefarious. That goes beyond Donna Adelson. Donna Adelson just wanted people to lie for her. She wasn't trying to take out the witnesses. And I don't think Kouri Richins was trying to take out witnesses either. I think she was trying to plant a story with them so they would all be on the same page, singing from the same hymn book as you were. They go on to say that why are we in Oregon? You're in Utah. Does this not happen in Utah? Do we not have a Utah case? Okay. The Oregon Supreme Court found the state's interpretation of the letter to be reasonable, if not compelled. It held that the letter was relevant to establish an inference of defendant's consciousness of guilt for murder, and that the defense was free to argue at trial that the letter, in fact, had another meaning. That's how that works. They cited some other case law on that. The defendant's Rule 404 argument is logically what word? Oh my goodness. The defendant's Rule 404 argument is logically erroneous and factually contradicted. 404 argument not found. The defendant cites 3 cases where courts admitted evidence of threats of physical harm to show an attempt to influence a witness and thus consciousness of guilt. She then argues that the court should not admit the walk the dog letter because it does not include a threat of physical harm and thus cannot give rise to consciousness of guilt. If that's really their argument, I agree with him. I don't think that's all of their argument, but also, well, I mean, it's not a threat, so it can't come in. Not how that works. Clearly, a jury could find that the walk the dog letter shows an attempt to influence a witness and thus consciousness of guilt, even though it does not contain a threat of physical harm. The defendant asserts the walk the dog letter is not consciousness of guilt evidence because, quote, the statements in the letter can just as easily be interpreted as a reminder as to what defendant's brother can truthfully testify about. Remember, the guy was never in the house. How did you interpret that in the Karen Reed case? Tell them the guy was never in the house. Is that a reminder of the truth? Or is that a say this thing? Wink, wink. Remember, I spent the night at your house last night. In case my mom asks. Emily, that sounds too real to life. Well, not anymore, because I'm an adult. Remember, we were home by 11. I mean, It goes on to say, this interpretation, however, is highly unlikely given the defendant's lengthy and repeated explanation in the walk the dog letter. Lengthy and repeated explanation that the walk the dog letter is a, quote, sloppy, rough draft of a, quote, freaking book wholly unconnected to Eric Richins' death. Jolene said, Emily, did your sons try to pull that off? No, that was me as a teen. That was me as a teen. Not my kiddos. My kiddos are, I like my own bed. Can you just pick me up at 11? Kind of sleepover kids, which works well for me. So, yep. So, Emily, where do these statements come from that the prosecution is quoting? Jail calls. They come from jail calls. Because when, I don't even remember what motion these jail calls are in, but when the defendant, Google Drive is making me nuts. When the defendant saw the news of the walk the dog letter break, she did what all defendants with unlimited phone calls do. She, ring-a-ding-ding. She got on the phone and started venting to her family members that this is all so stupid and this is a book and these prosecutors essentially are so dumb and why don't they understand? And this is absolutely not her trying to plant a story beneficial to her defense at all. This is such a misunderstanding. Ugh. Like, I can't even. Emily, how do we know this? Oh, we have a transcript of one of these calls. And it looks like the state is proposing to bring these in because defendant went on and on and on about how this is a book transcript. And then her attorneys were like, no, it's attorney-client communication. And I spent weeks yelling, it can't be both. Because the defendant tried to do damage control on the phone to her brother and mother on recorded jail calls before she ever talked to her attorneys. And then her attorneys tried to create a legal defense, and it was undermined again by Kouri's own statements. So, Ms. Richins, should talk to your attorneys before you started getting on the recorded telephone. Then again, on the recorded telephone, she was also calling her attorney names. So, you know, when you think you're smarter than everybody, we end up here. So the prosecution says that the walk the dog letter, based on the defendant's lengthy and repeated explanation, is a sloppy, rough draft of a freaking book wholly unconnected to Eric Richins' death. We have only seen transcripts of these calls. I cannot wait to hear these in trial. I am very interested. Emily, you said you wanted to hear all of the wiretaps in the Adelson case, and then you regretted it deeply. Yep. Still really want to hear them. Will Kouri Richins annoy us as deeply as Charlie Adelson? Who knows? We got some similar personality stuff going on. Who knows? The prosecution goes on to say, accordingly, as set forth in the motion, the walk the dog letter is admissible because the consciousness of guilt that it reveals proves the defendant's intent, plan, and identity in causing Eric Richins' death. And that's just quoting the rules there. Defendant's Rule 404 argument is legally... He's just coming up with new ways to tell the defense that they're wrong. The defendant's Rule 403 argument is legally imprecise and logically erroneous.
That's suspicious. That's weird.
Mr. Bloodworth, the paragraph headers are fantastic. So we're at legally imprecise, logically erroneous and factually contradicted, legally unsupported and factually inaccurate. too funny. It's just too funny. I'm here for it. All right. Where are we? Oh, legally imprecise. It's a great insult. Excuse me, counsel, you are legally imprecise. Under Utah Rule of Evidence 403, a district court may exclude otherwise relevant admissible evidence if its probative value is substantially outweighed by the danger of unfair prejudice. Right. More prejudicial than probative is kind of the shorthand you will hear from that. Things in a criminal trial are prejudicial. Like the prosecution has to take, the whatever analogy you want to use. They have to take a jury from, presumption of innocence all the way over to proof beyond a reasonable doubt. So the things that come in are going to be prejudicial, or they're probably not relevant. Like if something doesn't help you as a juror determine the defendant's guilt or not guilt, it's probably not relative or relevant. And if it is relevant, it's going to be prejudicial to the defendant in some way, some more than others. But it has to be outweighed by the unfair prejudice. It cannot be unfair. Sarah Boone's interview with police is highly prejudicial. It's also very probative, and it's not unfairly prejudicial. So that's where we get the moving the scale from presumption of innocence to beyond a reasonable doubt. The ruling, my monitor was doing something weird. The ruling goes on to say at the outset, the court must indulge a presumption in favor of admissibility. The probative value, and then it froze again. Something is going on with my connection to my third monitor. Migalina, will you make a note for me to look at this so I don't forget? I don't think I can forget, but this is the second time it has frozen on the screen there. So let me see. And the last time I changed this is when we started getting a little bit of echo, and I don't know if that was due to the refresh or if that was due to just the way that the video was. All right, there we go. That's strange. That's really strange. New problems. Yay. Thank you. It's it's odd. It's an odd issue. Where were we? Let's see. Oh, Rule 403. In applying Rule 403 balancing test, phrases like substantially outweighed, unfair prejudice, and rouse the jury to overmastering hostility. That's new to me. What case law is rouse the jury to overmastering hostility coming up? Lord. That's much. Well, I guess if the jury would just be super pissed off and it's really not all that probative, that's the balance. They go on to say the defendant does not argue from these legal standards, but instead cuts single words from the phrases and reassembles them to fabricate a more obliging standard. What a lovely turn of phrase, Mr. Bloodworth. Put artfully, we'll decide. Put artfully as set forth in the motion, the defendant's own words revealing her consciousness of guilt are highly probative because they bear directly on her agency in causing Eric Richins' death and are not subject to alternative proof. And any prejudice arising from her own words is not unfair because they are her own words and not the type of words that would rouse the jury to overmastering hostility. They did rouse EDB to some hostility when she was talking about her sister-in-law's kids. I was hostile. It definitely made me hostile. It made me real mad. If you think I'm hostile now, I'm teasing. No, I'm not. I'm movie quoting. And even if unfair, the danger of any unfair prejudice does not substantially outweigh the probative value of her own words revealing her consciousness of guilt. Moreover, contrary to the response, presenting the walk the dog letter to the jury will not confuse and mislead the jurors into thinking that they are deciding a witness tampering case instead of an aggravated murder case. Jurors are smarter than that. Is she telling her brother and mother to lie for her? And is she doing that because she knows she did something wrong? That's the question. Is she trying to come up with another story because she knows she did something wrong? Like murder her husband. Blower says jurors are smarter than that. Accordingly, as set forth in the motion, the walk the dog letter passes 403's balancing test. Conclusion, the court should determine that the first 3 pages of the walk the dog letter as redacted, consistent with the court's privilege determination, is admissible for trial as a statement of a party opponent. Her words, Your Honor. Her words. Let them in. We want to hear it. All right. So that was filed. When was this filed? Wait, where is the filing stamp on this? It was dated December 5th. I don't know if it was filed later than that where I grabbed it, but it was signed December 5th. It's been a busy month. There's been lots to cover. So I think it helps if maybe we look at the walk the dog letter. 85% of you agree. So I think we should just go look at the walk the dog letter. With over like 3,000 votes, 85% of you think we should just look at the walk the dog letter again. We will, of course, link our Kouri Richins playlist down below if you want to go look at other coverage of this case. Some cases I go into as a juror where I'm like, I know a little bit about this case, but not a ton. Some cases we start covering at the beginning. The beginning of this case was really interesting in that I was like, what children's book? What book tour? What are you talking about? And then the bond hearing was quite illuminating with the mortgage fraud and the other allegations of fraud. And I was like, oh, I want to know all about this. So we know quite a lot about this case. And I'm interested to see how things come in on the record, different from what we've seen in pretrial motions, because we don't have to be jurors. We don't have to go in not knowing about the case. We don't have to sit here and go, we know nothing, tell us what's in evidence. We can weigh what we know and what we see in trial against each other and keep an open mind to be like, well, what if it doesn't come in? Well, if it doesn't come in, the jury might come to the right result, even though I would have done something different based on information from outside of court, because information from outside of court doesn't count. And then you have to kind of segment the information, which is one of the top lawyer skills that's needed. What does the jury know? What do I know? Because when you're in trial, the attorneys always know more than the jury knows. They don't always, the judge doesn't always know more than the jury knows, but the attorneys know a lot more than the jury knows. So it is one of those things you just have to keep separate, and it is a skill to do so. All right, let me find the walk the dog letter, and then I will see. I don't even know where it is. There, as I said, there are quite a lot of docket items. I'll see if I can find the prosecutor's motion that includes the call transcript. And then we have 2 quick orders from the judge. All right, there's the walk the dog letter. Let me see if I can find those transcripts real fast, because they're pretty close in time to the walk the dog letter. And some of them are just illuminated in other motions though. So it might not be easy to ascertain, but let's see. Transcript of audio recordings. Perfect. I found the one I was thinking of. I don't know if it's all of them, but I found the one I was thinking of. All right. Walk the dog letter. For those of you that are new to the walk the dog letter. Oh, let me put up that poll. Have you read? All right, I'm just putting up a poll for if you've read or read with me the Walk the Dog letter. So if you've seen me cover it and read it with me, or if you've read it on your own, let me know. If you are new to the Walk the Dog letter, let me know. I'm very curious. Because for some of you, this is going to be new information. And that's just delightful. Kristen said, my brother and sister-in-law have both received the jury questionnaire. Oh, I'm so curious about what's on the jury questionnaire. Because those haven't been released either. I'm sure it's illuminating. I'm sure my name will pop up in a few of the jury questionnaire responses. This is a case that it's just going to come up because they're going to ask, "What do you watch?" And it will come up. So far, about 28% of you are new to the Walk the Dog letter. Oh, welcome, welcome, welcome.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
And yes, that actually did happen in court when Attorney Bloodworth was asking a witness about it. Let's talk about the Walk the Dog letter. Remember, the Walk the Dog letter was recovered by jail officials from Kouri Richins' jail cell. We actually watched the search of her jail cell when they found it. That was during one of the suppression hearings that we watched. The Walk the Dog letter is, as I said, docket 214. We're up to over 1,300 docket items. Docket 214 was on the record. Let me see what dates. Let me see what date this was connected with. This was, I'm looking at docket 216 real quick, not on screen, just to orient as to date. But this is around early September 2023. And so we have, there's more statements in this one too, in the motion for no contact. All right. So this was September 2023. Remember, she was arrested in May of 2023. The homicide is from March 2022, and the attempted murder is from February 14th, 2022. So this is not that long after she was arrested, but it was a bit of time after she was arrested. When we are going through the letter, Sky is the previous defense attorney. Sky had a conflict on the case related to the estate cases, because there are like 3 estate cases that are now all one case, but there are the estate cases and then this criminal case and now the fraud criminal case. So it was a conflict with regard to that. Though this letter would have put the defense on the back foot significantly, I can't imagine the rage. I can't even imagine the rage. Page 1, walk the dog, but take vague notes so you remember. Sky is saying, and this is underlined, even if, that is my underlined voice today, apparently, even if, Emily, she's writing in a letter what her attorney said. Isn't that starting to violate attorney-client privilege? Yeah, you're correct. Why would someone do that? Because they think they are smarter, and so they're going to do what they want to do, even if it's a bad idea. Look, man, this kind of letter as a prosecutor doesn't happen all the time. But when it does, holy shit, is that your best day at work ever? Your best day at work ever. It would be like, I don't know. I don't know how to describe this to the best day at work ever. The best day at work ever. Sky is saying, even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. The victim died with a significant amount of fentanyl in his system. There's a lot of other facts surrounding that. The prosecutors recovered marijuana gummies in the home, did not recover any fentanyl, and they tested them. And none of those gummies had any fentanyl in them. So, don't blame the gummies. Leave the gummies alone. So, the take vague notes so you remember with an asterisk indicates to me this is not a novel, right? That's just where I'm at on that. The prosecutor will say, I tried to put fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them though. However, underlined, she being Sky. This is the defendant telling her mother, because this letter's written to her mother, the defendant telling her mother what her defense attorney wants to argue a few months into the case. However, she wants to link Eric getting drugs and I can't see that one. Drugs in pens, maybe pens from Mexico. So we need some kind of connection. We need some kind of connection. Oh, pills. Some of you are saying it's pills. Pills, pens. Yep. I'm going to trust y'all. I'm dyslexic and this handwriting is hard to read. Pills does make sense. So we need some kind of connection. Her private investigator is doing some research on the ranch/cartel place where Eric would stay at. Here's what I'm thinking, but you have to talk to Ronnie. Ronnie's the brother. He would probably have to testify to this, but it's super short, not a lot to it. Okay, it's super short, not a lot to it. He will need to tell Sky at the meeting next week. My interpretation of this is only my interpretation. The defense is going to argue one thing, but if I'm reading this letter and I am reading it through the lens of a prosecutor, it is Sky said this is the defense, and I'm taking it into my own hands to make sure that my family is making those connections. And that my family making those connections, and this might be the privilege that they're trying to keep out, because if it was never shown to anyone, does it violate privilege or not? Those might have been the arguments. We didn't see those arguments. But it is, I need brother to go to the meeting and tell attorney this. Oh, we need a connection. Here's the connection. That's how I read it. Again, open to interpretation. Ronnie will probably have to testify to this, but it's super short, nothing to it. He'll need to tell Sky at the meeting next week. Upon information and belief, parentheses, just like they say. Ma'am, you can't just grab the legal words and think that they have meaning, but okay. A year prior to Eric's death, Ronnie was over watching football on Sunday, and Eric and Ronnie were talking about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch. Not to tell me, because I would get mad, because I always said he just gets high every night and won't help take care of the kids. Parentheses, oh, I forgot about this. There are pictures in my phone of Eric passed out on the floor or in the chair. Oh, more pictures of people sleeping? Ronnie should have texts from Eric talking about getting high as well. Leave the weed alone, Kouri. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I won't find them. Right. He just drives around Utah with them in his work truck. Okay. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them. Ronnie never told me about the conversation. So how do you know the conversation? Oh, that's right. That's right. How do you know? How do you know the conversation then, Kouri? Oh, because you're creating it in real time. You're workshopping it. Journaling. Manifestation. Eric finally told me and asked if Carmen could get him some. Oh! Carmen the informant. Hey, Trav. How are you? We're reading about crimes. I know. Here. T says hi, Leonards. I know. He's gotten too tall. He has to now bend down quite a lot to say hello on camera. Drive safe. Love you, buddy. Chat, do you hear George? George is like, why are you saying hi to the Leonards and not to me? Did you hear the yelling? I heard the yelling. Hi, buddy. I know. I'm not T. I'm not him. All right. Drive safe. Thanks for saying hi. Bye, George. Can you hear how loud that cat is? That's what it's like every time Travis gets home. Every time he gets home, George follows him around the house and is just like, pick me up. Talk to me. He knows what his car sounds like. So George is generally waiting by the door to the garage when Travis gets home. George is going to be so mad when Travis goes to college. He's going to be so mad. He was mad over the summer when Travis was on tour. It's going to be tough. All right. Speaking of tough, this story is tough for me to take as true. But we didn't know who Carmen was the very first time we read this, but Carmen is the informant who arranged the drug buys at the Maverick and Draper. That's Carmen. Eric. So now it's even setting up that Eric's the one who wanted her to reach out to Carmen, because at this point, Kouri would have known that in the discovery is the Facebook messages with her and Carmen and her asking Carmen for some stronger stuff and what have you. Kouri would know that by now. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. Oh, she's talking about drugs. Okay. I was going to say, and she has now switched into the way she wants her brother to say it. Right? Ronnie needs to say that Eric always wanted Kouri to be the one to get in trouble. So this is now what brother's going to say. When they traveled, Eric would put his drugs in Kouri's bag at the airlines. It's a weird way to say that. Right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag and it would cause a huge fight. Wait, I thought she didn't know about any of this. And now it's causing huge fights at the airlines, not the airport. Also, if he's buying all these drugs in Mexico, is he just bringing them home? And I thought when he brought them home, he was hiding them. So how would it cause a big fight? Also, why would he be trying to transport narcotics from Utah into Mexico? That doesn't even make sense. And nobody's going through the airport. How many times are you going through the airport with drugs and not getting caught? Really? I just don't believe you. At all. Because you clearly never got caught. Ma'am, are you watching too much Bridget Jones? What's happening in your mind? All right. It goes on to say it would cause a huge fight. And she was pissed that he would risk her going to jail for his drug use. Well, he just would laugh about it. Eric couldn't ruin his image that he had drug issues, so he would do whatever he had to. I mean, I guess I don't live in Utah. I don't know. Do people still get mad about weed? I guess some do. Kouri has never done any type of pills. Didn't like them. Well, how do you know you don't like them if you've never did them? Emily, you're not here to argue with Kouri. No, I'm not. But also, logic. Like just... Rarely would she consume THC, only if Eric begged her because it was a special occasion. Asterisks. Reword this however he needs to make the point. Just include it all. It's an editor's note. Sure, it's a novel. Reword this however he needs to, just to make the point, and just include it all. Mention it all. Wait, where? We need our mention it all.
Mention it all. Mention it all.
The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. Wait, did Kouri have Eric's phone? Wait. I don't know if they recovered Eric's phone. I wonder if she had Eric's phone, and I wonder for how long she had Eric's phone. I'm very curious if this comes up. I have an asterisk. I have questions asterisk. Asterisk. Did she have his phone, or was she logged into his iCloud on like a laptop or something? I'm curious. I don't know. But she said multiple times in this letter that she is so confident that her brother has the messages to prove that Eric confided in him about getting high. So it could be that she and her brother had conversations about this before this all went down. But it could also be that she had access to these digital devices Anyway, Ronnie will have the messages to prove Eric confided in him about getting high. It can be short and to the point, but has to be done. Do you ever refer to telling someone the truth as it has to be done? I mean, I guess so. Like if you're trying to tell a friend the truth about whatever, like sometimes the Band-Aid just needs to be ripped off. It has to be done. I don't know about this. It can be short and to the point, but has to be done. Upon information and belief, lol. It's literally LOL. And the L's are capitalized. I mean, this letter is an L that's capitalized for the defendant, not for the prosecution. The W prosecution on this letter. It goes on to say they never found pain pills or fentanyl in my house because he hid it in allergy bottle in work truck. Oh yeah, by this point, she's realized that when people accidentally OD, the thing that they accidentally OD on is where they are or near where they are or in their home somewhere. So, she goes on to say, Cody emptied out the work truck within a week. Well, I wonder if Cody's going to testify and be like, no, I didn't find drugs in the work truck. She goes on to say, so they were never found. So here's a reason why there's no fentanyl at the scene that was treated as a medical emergency, not as a crime scene. Page 3. When you talk, this is Kouri telling mom to talk to brother. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to Salt Lake or SL and meet him after work without Bree. Sky has to make the connection between Eric and Mexico because that makes the most sense in her mind. Okay. If it's Ronnie's information and belief about the conversation over football, she can use that as a connection. Tell Ronnie don't overanalyze it. It was a quick 2-minute conversation. Lol. Tell him I need him to do this. Bring me home, and then we will get those damn bitches. I forgot about that too. I think given the context of where we were in this case, those damn bitches are her sister-in-laws, but we'll see as this letter goes on. Bring me home. Doesn't sound like tell the truth. Doesn't sound like I'll be vindicated. Bring me home. And then we will get those damn bitches. I don't have adequate words to express both my empathy and rage for Eric Richins' family. I can't imagine going through, he passed in 2022. And we are in 2026. They are in a multifaceted litigation over Eric Richins' estate. One of his sisters has Eric's kids. And then this is the shit that she's saying that you know about while sitting in custody. I can't imagine. I just can't imagine. She goes on to say in her letter, also, please text Lotto or call. Tell him, do not text me anything about us doing things together ever. There are more than one side piece. Tell him not to text me anything about us doing things together ever. She goes on to say, like church, skiing trips, nothing that puts us together. It doesn't look good. Why doesn't it look good? No apostrophe. We're so close to the end. Emily, you're a dick for that. Yeah, maybe. This case makes me petty. It pisses me off. We're so close to the end. Let's push through. Emily, what year was this letter written again? Oh, 2023. September 2023. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. I'm shocked she didn't write burn after reading on this. Oh, and now we have a bullet point. It's not an asterisk this time. It's a bullet point. Take vague notes of all of this so you remember before you walk the dog. Which is a colloquial phrase. We're not literally talking about a dog. Page 4. Also, chat. Do any of you put your page numbers in the middle at the top? Or I guess there's no room at the bottom of these pages, but page 4. I saw a commercial yesterday, Utah Mortgage Relief. Google them, please. It's for people behind on their mortgage. Can you see if they can help at all on, I think that's Marissa's house, please? Asterisk, if you want to know more about the mortgages, we covered that when she got charged with the additional case. We have to get hers, yours, and Chelsea's taken care of ASAP. Yeah, there was a lot of financial stuff going on. Try to go to the place in Camas. What about asking Lotto to do a loan solely in his name and not have you on there? Remember, they're alleging that the mother has a house that belongs to the estate. Let's see. I know he can do a home equity line of credit on his house in Hideout. Look, man. Hey, T. You've got a quick question? Give me, Lawnards, give me 2 seconds. T's got a quick question. Hold on, I'm going to put our stretch music on. George, we heard you, buddy. And I will be 30 seconds. I'm going to see what T needs to ask. All right. Lawnards, be right back. Hold on. All right, Lawnards, let's resume. Bye, George. George is following Travis out. Thanks, everybody. All right. Let us resume. Hold on. Where did my other in-ear go? I took it out so I could hear Travis. And then it yeeted itself. All right. Let's see. Stacy said if the cats would stay in the smallish areas, we would need a cat cam. Oh yeah, that's not happening at all. Unfortunately, they are, well, maybe one day, but they're all over the place. These cats. Okay. I don't know who Lotto is. I think it'll illuminate itself later, but Do not take out a home equity line of credit to try to put these houses in your names. That's a terrible idea. Don't do any of that. Not at all. Kouri goes on to say, not sure if he would, but I know he has like $1 million in equity. A, why do you need that? B, or why do you know that? And B, like, who is, no. Maybe he just doesn't know about a HELOC, in parentheses, home equity. If he wants to help me, taking care of these loans is most important. I don't give a shit about the hotels. Okay. Remember, I hate this part too. Remember, I told you one way to get at Katie is going through my phone. Katie is the sister, one of the sister-in-laws who testified at the bond hearing. And so when she is talking about this, she is talking about her sister-in-law. I think this is the sister-in-law that has the children. And if I'm remembering accurately, I think this is the sister-in-law that she punched. I think so. Remember, I told you one way to get at Katie is going through my phone and finding a picture of her girls, even with the boys being Kouri's and Eric's kids. Print 15 copies and send them out anonymously to different media companies. Obviously, don't, no apostrophe, email the pictures so it's not traceable. She would be livid, underline, if it got out to the public. You would just have to do it sneakily and be careful. She would try and trace it back to you. If not, no worries, exclamation point. She wants to, and to my knowledge, this never happened. She wants her mother to send the media photos of children to intimidate her sister-in-law or to get at her sister-in-law, even if it includes her kids being put out in the media. These are her nieces. It tells you a lot about what Kouri's thinking, that it doesn't matter. So for those who are like, who would ever? Donna, Murdaugh, probably Girardi. Who would? I can tell you who would. If not, no worries. It's just disgusting behavior. Even if it doesn't happen, the thought process of let's use my nieces to go after my sister-in-law who lost her brother. It's continuing on. Sky, attorney, is having the My Girls do the first interview with Good Morning America. Oh, her friends. Please tell Chelsea to bring up that he hasn't, no apostrophe. And I think she's talking about the victim in this. Like, tell my friends to go on GMA and tell them that Eric is not going to church and is drinking. It's not giving, I'm horrified that my husband has died. Leslie in the chat said Brian Walsh would absolutely do this. Tell my friends to go on GMA and bring up the fact that my deceased husband hasn't been to church in the 13 years she has known him. And Eric would brag to her about how much he drank and did pills in high school. Oh, my screen froze again. Go on Good Morning America and tell them about what? Your deceased husband being a bad Mormon? Is that where we're at? Okay, Kouri. Tell Kelsey, underlined, to say, quote, Eric always wanted Kouri to go down for him. The same thing you want your brother to say then. So this is now tell Kelsey. Tell Kelsey. For example, he would put drugs in her suitcase when we would travel together. So if anyone got caught, it was Kouri. He would put it in her bag right before they left the house. I'm sorry. Earlier in this letter, it said that it was at the airlines. How is there an inconsistency in this story within the same fucking letter? Oh, that's right, because it's not true. Right. You guys, Eric didn't go to church enough, and he might have had weed gummies. Says the woman sitting in jail, accused of his murder. Like a choose your own adventure of what to say on Good Morning America. Anyway, Kouri is telling her mom to tell Kelsey that Eric, the victim, would put drugs in her bag right before they left the house so that Kouri didn't know, much like Scotty. And then when we would land wherever, Eric would take them out of her bag and Kouri would be pissed and they would get in and they would argue about it. I don't know if that's all. Something Kelsey to say how Eric didn't care, or tell, that's definitely tell. Tell Kelsey to say how Eric didn't care and would just laugh about it and say, well, I can't get in trouble. As if it was okay that I got in trouble. Have Selma talk about Eric in Spain not being able to drink, so he was looking for drugs the entire time. And explain the drink the waitress gave to him and how I called his doctor and went to the pharmacy immediately. Have Allie talk about how the sisters... How did I forget all of this? There's so much in this case. How did I forget about this? Have Allie talk about how the sisters, so her sister-in-laws, have always been jealous of me. Because anything they could do, Kouri could do better. Being a mom, college, stay-at-home wife until she built $1 million company. Ma'am, it is not $1 million company if you are $1 million in debt. That's not how that works. I built $1 million company. It was all debt. That doesn't count. That's not how it works. They were jealous of me because I was better at being... I've ranted about this part of this letter and then I keep like purging it from my mind. Parenting is not a competitive sport. Do not be friends with people like Kouri. Better at being a mom. better at college. And you're bad at Googling, girl. I'm going to keep the rest of those thoughts in my head until later. She was a stay-at-home wife until she built $1 million company, a nice house, car, everything she had, they wanted. Ma'am, it was a house of cards that collapsed pretty spectacularly. It goes on to say, this comes down to jealousy, money, and Eric's partying that they don't want to acknowledge, and sadly, an accidental overdose. I agree with the money part. Lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it to use in our defense. This has to do with Eric's guns that were in the safe and when the safe was taken from, I think when the sister took over the safe, I think is what that has to do with. I don't know if any of the guns were or were not registered. It doesn't matter in this case if they were sitting in the safe at home and no one was shot in this case. We want to file charges and let the prosecutor not do anything about it. Charges against who? The executor of the estate? Moving on. Will you buy a box of Crest White strips? Open them up and put in an envelope and have Sky give them to me? You can tell her what's in the envelope. I'm sure she won't care. No, your attorney will care if you're trying to smuggle contraband into custody. Crest White strips are contraband. You're not out of custody. No white strips for you. No. Yeah, your attorney would mind that. Any attorney would mind that. I'm sure she won't care. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee and tea all day. Got to keep up perception, you guys. It matters the most. I'm sorry, frowny face. My teeth are yellow from so much coffee and tea all day, frowny face. It goes on to say, I love you, I love you, I love you. Hang in there. We're getting there. You're not. Slowly. You're, while you are, the best mom in the whole world. I'm so lucky to have you. That's the walk the dog letter. Can you see why the prosecution would like to use this as consciousness of guilt? Because even if they take out some of the things that maybe are more salacious or could rile the anger of the jury, like if they took out the part about go through my phone and find photos of the kids and give it to the media, if they took that part out, it still tells you that she is making a story. Tell these people to say this on Good Morning America. Tell brother to say this to lawyer. It is coordinating all the pieces on the board for her defense and trying to get all of these different pieces to say, oh no, this was an accidental overdose. Sure, girl. So I think the walk the dog letter will come in. I think there will be some redactions to it. I could see them redacting out the part about the sister-in-law. However, if the sister-in-law ends up testifying for some reason, it might come in at another point or might come in a different way, but we'll see. But like the whole letter is just like, sure, Jan, the entire thing. Because it's not a book, but I think it's only fair if we take a look at what the prosecutors filed with regard to the stay away, because it has some of the phone call snippets in it, even though it's old. I think we look at that and then we look at the court's orders. Yeah. Yeah. I think that sounds like a good plan to me too. Chat, I agree with you. And let me see. I pulled that up. I now have too many tabs open. The prosecution, to my memory, did not get the no contact order between Kouri Richins and her mother, but were asking for it. And then they filed the transcript of the jail calls along with it. And we'll go over that transcript real quick. So let's look at the motion for no contact order in connection with the walk the dog letter. And let's see. This is, can we embiggen, please? Thank you. Motion for no contact order. The state of Utah respectfully requests the court enter a no contact order to prevent the defendant from further engaging in witness tampering. They never charged her with witness tampering. Statement of facts. The defendant is being held without bail in Summit County Jail pursuant to policy docket 213, footnote 1. On September 14th, 2023, Summit County Sheriff's deputies searched the cell block where the defendant is housed, including the defendant's cell. The search revealed a 6-page handwritten letter that defendant wrote to her mother, Lisa Darden, hidden inside a book in the defendant's cell. The letter instructs Lisa Darden to induce the brother, Ronald Darden, who is Lisa's son, to testify falsely in this matter. The letter claims defense counsel, quote, wants to link Eric Richins getting drugs and pills from Mexico to the fentanyl that caused his death. No such link exists. Therefore, defendant concocts a false narrative for Ronald Darden to repeat, whereby, quote, Eric told Ronnie that he got pain pills and fentanyl from Mexico from the workers at the ranch. She allows that Ronald Darden can, quote, reword the narrative however he needs to make the point just include it all. The defendant explains that Ronald Darden probably would need to testify to the narrative, but it's super short. Not a lot to it. Can be short and to the point, but has to be done. Tell Ronald I need him to do this. The defendant cautions Lisa Darden to convey the instructions to Ronald Darden in person because she worries that Lisa Darden's house and phone are bugged. Right. 31% of you, by the way, had not gone through the walk the dog letter yet. So welcome to this case. They go on to talk about the witness tampering. They did not charge it. The court did not issue the stay away. I was looking for the footnote. Let's see. Defendant passed this exact letter or its contents to Lisa Darden, or no, they're talking about it's unclear whether the defendant passed it. They talk about where the letter was found. Let's see. The letter establishes that defendant trusts that her brother will testify falsely and that her mother will facilitate his false testimony. Tell Ronald I need him to do this. Moreover, it establishes that the defendant is willing to witness tamper through a third party, that the defendant hid the letter in a book and showed another now missing letter to her mother over a video call further indicates that she understands the wrongfulness of its contents and purpose. And then they ask for the no contact order. Footnote 2. The letter also instructs Lisa to tell defendant's friends what to say, but this appears to be referring to a, quote, Good Morning America interview defense counsel allegedly arranged, and then they have that quoted. So in connection with all of this, we also have the one of the jail call transcripts relating to the conversation between Kouri and her brother. This is fairly long, so we are going to go through it as quickly as we can because I have gone through this a couple times before. And again, we will link that. But we're going to go through, well, I say that. We're going to go through some of the highlights. It is a 25-page transcript of a jail call after the walk the dog letter hit the media. Are you ready, law nerds? Emily, you said that reading all day. I know. Emily, but transcripts, I know. Curiosity took the wheel. And away we go. Mr. Ronnie Darden. Hey, Kouri Richins. Hi. What are you doing? Ronnie, working. So what? You can call but not text? Kouri. I guess so. I don't know. There has to be some kind of mix up because I think because the guy that did my like disciplinary action yesterday, he never said I couldn't text like message. He said I had to video call. So she got in trouble. At some point, Kouri then says the deputies here say, no, he needs, okay, so this is what the sentence says. Limit phone calls. It says limit phone calls to voice only and only handwritten letters out 90 days. So after the walk the dog letter, Kouri was only allowed audio calls, so she couldn't try like holding up the paper to the screen, and only handwritten letters out, no emails. Ronnie says, for what? And Kouri says, exactly, what does that mean? Girl, it means you got caught and you got in trouble. Ronnie says, you literally didn't do anything. Like, what the hell are they disciplining you for? Kouri says, and then I'm on 30 days of lockdown, 23 hours a day, no commissary. Ronnie says, for what? Like, they have to give you a reason. Kouri, for the paperwork, that's what they're saying. For my paperwork that they illegally found, which I wasn't hiding. But, you know. Walk the dog letter. But I wasn't hiding it, but you know. Also, it wasn't illegally found. The court already ruled on that. Ronnie says, for your paper, what does that have to do with the jail? What does that have to do with your behavior in the jail? Trying to dissuade witnesses is a problem. Law enforcement does see that as a problem. They see that as a problem. Mm-hmm. So Ronnie's like, what does that have to do with anything? Kouri's like, well, I guess the jail gets to do disciplinary actions too, is what they're saying. Yeah, ma'am, you're in timeout. You're in timeout. They're trying to say like my paperwork was contraband. Ronnie says, like, you stuck it in there? What the hell does that mean? Kouri, well, it doesn't make, they could just try to stack as many things on there as they could. Like, there's 3 different, they called them findings because she went to a disciplinary hearing. Ronnie says contraband means any item that's relating is illegal to be possessed or sold. Yeah, almost anything can be contraband in custody because what you're allowed to have is limited. Kouri Richins, yeah. Ronnie, like, what the fuck are you talking about? Drugs in Mexico, Ronnie? Ronnie, like, what the fuck are you talking about? Kouri, I know. It doesn't make any freaking... Hold on a sec. Oh, I don't know what she said. Anyway, I have no idea how one freaking relates to the other. Ronnie, it doesn't. Those fucking piece of shit Park City police told the jail what to do. Ronnie is like ride or die at this point. Kouri's like, yeah. Ronnie's like, that's what fucking happened. How would Park City even know the letter was there though? Ronnie, Kouri, that's what it comes down to. Well, they just keep saying it's a letter. It was never a letter. Like, I can't help it. Chat, I can't stop myself.
That's what it comes down to. Well, they just keep saying it's a letter. It was never a letter. Like, it was part of a freaking book. Like, it was never a letter. It was never in an envelope.
Right. Because the envelope's what determines it. It's the envelope. It's the envelope that's going to do it, y'all. It wasn't in an envelope. Ergo, no letter. Ronnie, it was part of the book you're writing? Kouri.
Yeah. So I was like, writing this book. I'm working late because I'm an author. No, ma'am. You're in jail. You have nothing else to do. So I was was writing this book. So basically, it's like everything that happened up to like the detention hearing, you know? And then at the detention hearing, I actually get out of jail. So it's like a fiction mystery kind of book, you know? Like, you know? And stuff.
She goes on to say, so anyways, at the detention hearing, I actually get out and I'm on a mission to go to Mexico to like find these pills. And I like call dad up and I'm like,
Dad, you've got to come with me to do this. Like, it's a whole fiction mystery book. And so, like, obviously it's not real. Like when my dad has been dead for 2 years.
you guys, obviously it's a fiction mystery because she's going to get on her vigilante shit and go find those pills, showing that she's not at all a flight risk when she gets out at her detention hearing and flees the country to Mexico. Like that. She's ready. Oh my God. You better be careful, Kouri. That cat eye isn't going to come off if you try to do it in Sharpie in custody. It's going to be stuck. It's going to be stuck on there. If those things are not even, it's going to be a big old mess. So she's saying it's like this whole fiction mystery. Ronnie's like, yeah, I'm going to fall over when we hear this in custody. So when we hear this in trial, when we hear the call from custody in trial, I'm going to fall over. Kouri's like, so me and dad go to Mexico. I mean, it's like this really long, like 60 something page book. Ma'am, that's a pamphlet. You guys, it's a really long. Emily, don't page shame. No, I'm allowing it on this one. It's a really long 60-page book. Ronnie goes, oh shit, yeah. And Kouri goes, me and dad go to Mexico and we get to the ranch that Eric stayed at. And then we find out there's human trafficking. And then dad is trying to like find out like who sold it to him. And it was the guy in the kitchen with the candlestick or what? It was the guy in the kitchen. And then we're like, oh my gosh, we got it. And we recorded it. Like, Ronnie, this is how ridiculous this thing is. I'm not kidding. So then dad's like, oh, it's the guy from the kitchen. Like, he just sold me some. Did you name the guy in the kitchen Walter? I've got questions. And I was like, oh my God, there's human trafficking here. We got to go. Wow. That's a lot. Lona said Mr. Bloworth must have cackled himself for weeks after listening to these calls. Oh, I imagine in less than a 60-page book that there were times where he's like, you guys have to get in here. Guys! I mean, I don't know if they all work in the same office. I'm assuming where you're on the same hallway. You guys have to come in here. You're never going to... Guys! You're never going to believe this. Office now. Either that or you take over the PA system. Excuse me, counsel, I'm going to need you to come to my office, please. We need to discuss some jail calls. Thank you. And then I imagine that there are days when his colleagues are like, Brad, it's the guy in the kitchen. It's the guy in the kitchen. It's the guy in the kitchen. Oh, yes. This is an inside joke that is not going to end. Brad, it's the guy in the kitchen. I also love that somehow Kouri's standing in a place and goes, "There's human trafficking here." Okay. How'd you figure that out? I divined it from the universe. Anyway, it goes on. So we go back across the border. I get arrested because I was out on bail and not supposed to leave the state. Look, there's the self-awareness. There it is. Here's the self-awareness. There it is. Right there. Right there. There it is. Anyway, so we go back to cross the border. I get arrested because I was out on bail and not supposed to leave the state. I write you and mom like this letter from Mexico prison. First of all, if you were out on bail from the U.S. and you were crossing the U.S.-Mexico border, you would be held in custody in the U.S. because Mexico's not gonna. They would just send you back to Utah. They're not trying to keep you. Oh my God. The caffeinated feline said, and then Ron saved her. And then Ron, like, because then she gets held in LA, right? So she's trying to tell this story to the Mexican authorities. And the Mexican authorities are like, "Ma'am, I'm going to need you to take 3 steps that way." And they push her over the border. And then they look at U.S. Border Patrol and they're like, "Hey, yeah, she's yours. Please take her." But then they can't extradite her all the way up to Utah. So they have to stop in LA. And that's when she gets on the phone to find a celebrity attorney who works in Beverly Hills and calls up the office and is like, "Look, my brother's name is Ronnie. Your name is Ron. I feel like you have to be my lawyer." And Ronald's like, "I am a celebrity attorney and I can do magic. This is the best. I think we've just decided to." Melody said, "Oh my God, Emily's now co-writing fanfic live." I think we have to finish the book, and we have now gotten well into the weeds of how this story goes, because of course she's just, you know, she has to stop in LA before they can get her back to custody. Right. And then she writes the walk the dog letter. Right. So wait, where did, so they cross the border. Okay. Anyway, so we go back to cross the border. I get arrested because I was out on bail. I write to you and mom from like Mexico prison. Is that like Mexico Coke? Like we're not even conjugating. Anyway, I'm like, "Get me out. Like, you got to come." Like all this stuff, you know, like Like, you got to tell them. And like, "I can't believe this is happening." And then I get out of Mexico jail, and then the trial starts, and then I write about the trial, who's testifying. Like, they literally took these papers out of the story. Ronnie, "Oh my God, are you serious?" I know, Ronnie, it's also unbelievable to us. Ronnie, we also are in disbelief. "Oh my God, are you..." Ronnie, no, this is not like, "Oh my God, are you serious?" Ronnie, this is like, "Bitch, are you for real? Like, you surely can't be serious. Like, you..." Beg your pardon? Mm-hmm. Kouri goes, "Yeah, that's what I'm trying to say. It's a 65-page novel." Oh, we're just tacking on pages now? It's a 65-page novel. They read the whole thing. And on the front of the novel, this is the worst part. On the front of the book, it literally says, "These are true events that have happened in my life." But the statements, the events, or this is surrounding, it says something like, she's workshopping it on the phone. These are surrounding the events of my life, but the statements, the events, and the way that it all plays out have been falsified for a fiction novel. It's called To Hell and Back. None of this can be used against me. This is only a book. None of this can be used against me. This is only a book. Ma'am, ask Keefe D. Ask Keefe. Ask Courthouse Becky. None of this can be used against. Ask Sheena Shea. None of this can be used against me. It's only a book. It's not how it works. I need to see the front page. Does it really say none of this can be used against me? Come on. She goes, so they read the whole and, oh gosh. She says, so, wait, where is it? She says, so they read the whole and Ronnie says, are you fucking serious? And I don't know what tone he said that in, but he sounds like he's on her side. So I think that Ronnie is saying, are you fucking serious? Not like, are you fucking serious? She says, yes, that is why this is so crazy. So they read the whole book, but only took out the 3 pages and they sent them knowing that it isn't what it said on the front of it. We watched them search. They did not sit down and read a 65-page novel. They didn't sit down and read any of it. They flipped through the shit on the bed and then took the pages that were hidden in the book out. We watched them do it in the suppression hearing. Yeah, that's what's so crazy. They read the whole book. Can you imagine? And then cut to scene. 2 prison guards sitting on the top bunk with Kouri's manuscript, reading it to one another like a bedtime story. Oh my God, there's human trafficking here. We have to go. Bob, you're never going to believe it. No, we'll watch Commander. We're going to finish in a few minutes. We need to know how the story ends. Could someone bring me a soda? Sure. Uh-huh. Mm-hmm. We need to know what happens. Oh, wait, she's in custody with us. Just kidding. We know the ending. Ronnie, are you fucking serious? Kouri, yes. That's why this is crazy. So they read the whole book, but only took out the 3 pages that they sent them, knowing that that's what it said on the front of it, knowing that I'm talking about going to Mexico with my dad that's passed away. Like what? Not the dead dad. Stop it, Kouri. Ronnie, I have some more questions about that because yeah, it definitely does not read that way. Oh, Ronnie, you are correct. It definitely doesn't read that way. No, it does not. And the reason he's saying that is because this hit the public docket and everyone has it. Doesn't read that way, like at all, obviously, because they pick and choose. I don't know about that. Kouri says they pick and choose. And it even talks about, like, I said something about, like, I want Sky to get me white strips. We remember. Something like da-da-da-da-da. And then the thing is, so, like, I get locked down because I got, like, white strips in. And, like, I put, like, I don't know, some girl told me on me or something. It was Donna. Donna's the snitch. Because if anyone's going to have white teeth before trial, it's Donna. Donna would definitely snitch on you and try to steal your white strips. For sure. Could you imagine these 2 personalities? She goes on to say, like I write this whole thing and then it talks about like the media stuff and like, oh my gosh, now I'm in Mexico prison. And like the media is going to go crazy. Oh, that's why you need the white strips for your close-up. Do you think she's trying to figure out how like Ruby Frankie got her hair rolled for sentencing? Because Ruby's hair was like rolled for sentencing or for plea, I guess. I wonder. I'm sure they'll have fascinating conversations. The media is going to go crazy. I'm sorry, I'm back to reading directly from the transcript. If you're listening in the background, when I start sounding like a 16-year-old, it's just me reading from the transcript. Some of it's a lot of the first 6 chapters are all like true what, like everything that's played out, you know? No, we don't know. We don't know. Ronnie, yeah. Ronnie, you don't fucking know either. You don't. Nobody knows. That's not even a sentence. Some of it's a lot of the first 6 chapters are all true what everything that's played out, you know? No. No one knows. Also, the first 6 chapters, are we at 10 pages a chapter, I guess then? Ronnie, yeah. Kouri, the last of it is kind of altered. And I said, some of it's true, some of it's not. It's, it's a book. It's a fiction book. And then I said something like, the media is going to go crazy. You have to tell, I don't remember who I said, somebody about doing media. And then had posted this picture of the kids. So I was like, you posted that? This is crazy. Get me out of prison. Blah, 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 blah. I don't say blah, blah, blah. Blah, blah, blah. Blah, blah, blah. It is this long, long thing. And that's what they nitpicked. Ronnie, do you have all the other pages? Kouri, yeah. Does Sky know this? Yeah, I told her. I gave it to her. Ronnie, oh my God. I know. I gave it to her and I showed her the front of it and it was all in my Sky folder because I don't know how much I can say. I don't, because it's all just, some of it's true. Some of it's not. Some of it's altered. It's just, I don't know what I can and can't say in this book, you know? So obviously it's fiction if I'm in a Mexico prison and we're already going to trial. Ronnie goes, and Dad's alive. Kouri's like, Dad, yeah. So this is, I imagine, going to come up at trial where she's building this whole story around the fact that it's a book. Dad's on a hunting trip. I imagine she is probably going to testify. I don't think that's a good idea. Then again, I've said that a couple times. And it hasn't happened, but it's giving she's going to testify. And at one of the last hearings, her attorney was talking about the fact that they needed to incorporate the time for her to testify in the trial estimate. Thank you, Sunzi. And he hasn't been home for a couple days. Thank you, everybody in the chat. Everybody in the chat who was like, Dad's on a hunting trip. Thank you. So when the attorneys were talking about this, it was she's going to testify. We need to make sure we have enough time to testify. It's giving Murdaugh. And I think there's so many of her words, she's going to want to explain that they're picking and choosing. And I think she will believe that she will be charming to the jury. And she's just a mama. She's just a mom. She's just a girl. You guys, she girl bossed not $1 million company and these bitches be jealous. That is what I think is going to happen. So they keep going on about this being a story. Kouri saying that all these pages go like, this is together. First of all, can we just cut the shit real quick? Hold on. Where is the walk the dog letter? This is from the middle of the book, y'all. It's from the middle of the book. Y'all, it's from the middle of the book. Page 1. You guys, they took it from the middle of the book. And it says you can't use this against me. It's just a book. Page 1. Okay. Sure. What in the world? All right, let's see. Where's our back to our transcript? Back to our transcript. Kouri, these pages go like, this is together. And on the front of it, it says like the title on the front. Page negative. The negative numbers count like page 0. It's like the millions, right? It doesn't plus minus, kind of irrelevant. Sure. And the front of it says like the title, the characters, like, because I didn't change on the front of it, I had like, your name's Vinny. Okay, Ronnie. I don't know why, but I have like all the characters and then what their names are going to be changed to. Right, because it's real. It's not a novel. But like when I'm writing, it's like confusing to think like, okay, wait, who was Stella? Who was you? You know? Ronnie's like, oh yeah, totally. So I use all of them and then I go back and change the names. There's like she's saying that they're all on the front of the book. They're all on the front of the book. She has like my brain has stopped, but she's correlating the names. She has like a guide to correlate the names. A legend. Thank you, chat. You're the legend. Thank you, Tracy. That's exactly what I meant. And it even says like the title. These are the chapters. These are the characters. These are the days of our lives. Ronnie then says, are you fucking serious? And Kouri says, nothing on this can be used against me. Like, this is all a mystery fiction book. It's all, which makes sense because the girl said that they had checked my cell like 6 times. And one of the times they spent like 2 hours. And I was like, so they were reading through the whole book. They were not there for 2 hours. They were not there for 2 hours. And I was like, so they were reading through the whole book. Ronnie, yeah, they knew what the hell they had. Yes, evidence. They looked at the first paragraph. Tell Ronnie to tell my lawyer. Take it. Just take it. Ronnie, they knew it was a fucking bullshit book. Chat, does that chat read like a book to you or nah? Ronnie's like, and they're like, oh no, it looks like it could be de crime. The translation of this or the transcription of this says DECRIM. I'm going with de crime. This looks good. Ronnie says, yeah, decriminating. Wait, did he say incriminating? Did he mean incriminating and said decriminating? Is that a typo? Or is that him? I'm curious. Decriminating. Is that a type of criming? The decriminating? Not incriminating. Okay. They know what they're talking about. Ronnie says, yeah, let's see this one. Oh my fucking God. Kouri says, I know. That's why I'm telling you. This is insane. There was never a letter. There was never a letter in a book in an envelope. There was like, this was never a letter. Like, what the fuck are you talking about? Ronnie, does mom know this? Yeah, I told her. But she was like halfway listening. And I'm like, Mom, I'm trying to tell you what to tell my brother so I can get the fuck out of here and make those bitches pay, Mom. Come on. Mom! Are you playing Midas Merge? What are you doing? Listen to me. Mommy. Mama. Mother. Mom. She was like halfway listening. Ronnie, when did you tell her? Kouri, a couple days ago. Oh no, the first day. I think it was the first day when I got locked down. Ronnie, well, she clearly was not listening because she has not told me that. She wasn't listening to you at all. Kouri, I don't think she was. And I'm like, Mom, are you hearing what I'm saying? And she's like, yeah, so anyway. And I'm like, oh my hell. So I was like, okay. So I don't know if she told DJ. I don't know if she told you. I don't know. But Sky has the freaking book. Ronnie, nope. This is the first time I'm hearing about it. Kouri, yeah, it was pretty interesting too. What, the book? Like, they go and we're like, no, it's in the transcript. She literally says, like, they go and we're like, yeah, it was pretty interesting too. Like, they go and we're like, Dad and I, like, we're hunting. Dad's on a hunting trip. And we like, the Mexico guys were up on a cliff and we have to pretend like, like how we, like, Ronnie, it was such a detailed book. I'm not shitting you. Like, what the fuck, man, is happening? You guys, the 65-page book. And then, like, we find out Marco, the guy in the kitchen, is the one that sells the pills, and we get some from him. But then there's like all these like 15 and 16-year-old girls that are like getting human trafficked because they have this like 4th of July party. Oh, I forgot. I forgot about how much Mexico loves celebrating the 4th of July. My bad, Kouri. I had forgotten about the 4th of July party and the trafficked girls. Kouri, if they were cartel that was trafficking, how did you get to the border, girl? I mean, if you're out on bail and you've escaped custody, I mean, people might be looking for you, but yeah. So the teenage girls human trafficking 4th of July party. Brother responds, why did they have a 4th of July party? That doesn't make any sense. Ronnie, she's making it up on the phone with you. Ronnie, facts, Ronnie. Why did they have a 4th of July party? That doesn't make any sense. Thank you, Ronnie. Somebody's actually just, giving us the truth here. Kouri, yeah, I know. And it even says in there like Mexican, like, we don't know if we're going to have a party. Ronnie's like, what the fuck? Ronnie says, like, an Independence Day? Kouri says, because we're in Mexico. Right, Kouri. Right. Kouri says, because I had just gotten, like, released on the detention hearing and I wanted to get to Mexico, like, right ASAP. So it was, now she's changing the story so she doesn't seem, the way she seems. So it was like, we were getting to Mexico on like the 3rd. And then like Dad says, well, this will be perfect. Maybe they'll just celebrate anyway. And that's when like the party and the drugs will come out. Right? Because she's making it up. Because she's making it up as she goes. And I was like, okay, cool. Good idea. And then we find out that they really are having a party and like they bring in truckloads of beer and cerveza, ma'am, and all this stuff. But really, it's not just a party. And then back to the human trafficking. No mention of fireworks. What's happening? Ronnie at this point goes, yeah. Ronnie, how much are the recorded, how much are the calls in Utah, Ronnie? Are we like $3 a minute, $5 a minute, like 50 cents a minute? How much is this collect call costing you, Ronnie? Yeah. Kouri. And I write how like all these guys and women are getting dressed to the T, but then like they have these like 15 and 16-year-old girls with them that like their makeup running down their face. And they're like, you know, like rocking back and forth. Like you can tell they're so drugged. Okay, Kouri. And then I overhear a conversation with some guy that says, hey, I'll give you 10 grand for that girl. That's not Kouri. Okay. Jennifer in the chat says, I have to keep looking at the screen to see if this is real or EDB just having fun with us. No, this is yeah. This is Kouri. So we're continuing on. Just continuing on. Oh God. This Tara said, turn the book into a musical. Bloodworth wears taps. I was thinking a cape. Bloodworth wears a cape. It's going to turn into like Dracula the musical. I can't. It's such an incredibly sad case. And she is so ridiculous. Like all of this is so ridiculous. It's so ridiculous. Which is going to be real interesting when they play this call of Kouri trying to explain that it's just a book, you guys. It's totally believable. It's totally believable that it's just a book. So Kouri is trying to explain that she hears someone trying to sell someone for like 10 grand. And Ronnie says, oh my God, no, dude. Everyone is blowing, apparently. I don't know. You know, I don't watch the news, but no, they're all blowing up about this. Ronnie trying to change the conversation. Kouri Richins, yeah, like Ronnie. So that's fucking unreal. No, Ronnie, what's unreal is the fucking letter. The letter is what's unreal. We need second water. The letter. Of course the media is like, oh, what? This is bananas. Kouri, like at some point I hope Sky's going to say like what it really is. Ronnie, I'm sure that she will. I don't think that anybody knew. Like mom told me this as I was going in to do, I was a little busy and I was like blowing up. And then I got a call from a reporter and I was like, I don't know what the fuck you're talking about. Like I was kind of pretty damn pissy with them because they like instantly asked. And I was like, how the fuck do you even know about this? Because she wrote it. Write it, regret it, Ronnie. And she was like, well, they're talking about this and this. And I was like, what are you talking about, dude? I don't know what you're talking about. Like, I got pretty shitty with them. I wonder what reporter called Ronnie that he popped off on. Kouri says, uh-huh. And Ronnie says, but yeah, no. Like, did y'all, where are y'all, It's giving California, not Utah. Ronnie, but yeah, no, like apparently you're freaking, it's all over the damn place. So, I mean, that's really good now. I'm sure that Sky's going to come out and say it. Kouri, I hope so. It's even like dated back to when, like, it's just so crazy how like out of context everything is. I'm sorry. We read page 1 through page 6. And at the end, there was like a salutation. Goodbye. Like, sure. Sure. But out of context. And then there's a lot of like, yeah, right. Like, duh. Like, Ronnie then says, yeah, no, not no, yeah. Like, yeah, no. It makes Sky's thing was actually really good. Like, they did it illegally, first of all. Second, the gag order doesn't fucking like, it's already out in the public docket. It's already out in the public eye. Like, they're trying to fuck her entire trial. The prosecution can't share this if Kouri doesn't write it. Ronnie, even if it comes out, you know, even if it comes out as being a book, like, we'll still like, this is all, they're trying to fuck her entire trial to taint a damn jury. Kouri, Ronnie, and it's obvious that's what they're doing. Kouri, right. Ronnie, because they're that desperate. It's so unbelievable. The letter is unbelievable, I agree. The letter's unbelievable. Kouri, and that thing you were looking for the other day, they did not do it. I'm telling you, it was not done intentionally. Ronnie, that thing I was looking for the other day? Kouri, yeah, the inaudible. Ronnie, oh yeah, inaudible. Yep. The thing. The thing. Ronnie, they didn't do it intentionally? Kouri, intentionally did not do it. No, they did not. They did intentionally? Kouri, no, not do it. Ronnie, you just said they did not do it. Kouri, yeah, Ronnie, yeah, Kouri, it was never done. The specific thing was never done. They made sure it was never done intentionally. Oh, Sarah Boone, what are we talking about? Intentionally. Ronnie, yeah, that is bonkers. Kouri, yeah. Ronnie, these fucking morons. Kouri, because if it was done, it would show, you know? Ronnie, that they fucked up? Kouri, what the, yeah. Ronnie, yeah, holy shit. Kouri, yeah, I can't. Ronnie, no, she didn't. Kouri, huh? Ronnie, go ahead. Oh, no, I know she wasn't like paying attention when I'm trying to tell her, oh, this jumps in the conversation back. It seems like this jumps in the conversation talking about mom. Oh no, I know she wasn't like paying attention when I'm like trying to tell her, but you know how she does. Ronnie, yeah, well, mom was just on the phone with Sky and she said, you're not allowed to call her anymore. Interesting. Kouri, wait, what? Ronnie, mom was just on the, or mom texted Sky just saying, hey, this is what Kouri can't text for 90 days and do this, that, and the other, whatever. I just want to let you know. And I guess Sky told her she can't talk to her on the phone anymore, you on the phone anymore. Kouri said, what? She just barely said that? Ronnie, yeah. And I was like, what did you say back to her? And I was like, well, no, think again. She goes, I didn't do anything, but mom did not hear you worth a damn. She was definitely zoning out when you said that. Otherwise, she'd say something if she's still referring to if she's still referring to it as a letter. Kouri, oh my gosh, it was never a letter. Oh my God. Oh my gosh, it was never a letter. Ronnie, I know this is fucking Kouri. Well, you'll have to explain it to her. Ronnie, I'm going to call her as soon as I get off the phone. Kouri, well, it's going to hang up in a minute, so I just wanted to check in. Uh-huh. Ronnie, well, cool. Kouri, don't freak out at Sky. Ronnie, I'm not. That's all. I was like, So she had like this whole thing that she was going to write. And I was like, no. Just say nope. Think again. Sky's going to file whatever she wants, but you can't tell a mother not to talk to her daughter. Who else is she going to talk to all day? Kouri, yeah, I get it. But all right. Well, you can give mom a call. I'll let you go. Ronnie, okay, I'm going to call her right now. Jesus. Take the wheel, perhaps. Kouri, okay, love you, bye. Ronnie, love you, bye. Audio recording concluded. So, when that gets played for the jury, I hope they have the transcript with them because it seems that there's a lot of them talking over each other. But the reason that's going to come in trial is because it gives context to the walk the dog letter. It's not a letter. It gives context to the walk the dog letter that goes to the consciousness of guilt, not to the once upon a time in Mexico of it all. So it's going to be interesting to hear that, not the way like I hear it in my head, but the way it's actually said, because we've only had the transcript, of course. And it will be interesting to hear no, yeah, like, yeah, no. Like, no, yeah. Dad's on a hunting trip. It's going to be interesting. Of the 65 page, very, very detailed book of the cartel standing in front of randos going, hey, I'll sell you that person for $10,000. Sure. The court had two rulings that we didn't get to. So we're going to go to those really quick because, well, I said we were going to, and then we side quested, but I think it was worth a side quest to just refresh our recollection of where we are in the magical mystery ride that is the Kouri Richins thought process. We'll go with thought process. So this is the ruling and order denying defendant's motion to reconsider bail and release. We're going to look at the court's reasoning just a little bit. Remember, the defense asked with new circumstances that I did not agree with. But the defense asked with new circumstances, hey, can you let Kouri out now? Because one of the witnesses said that he doesn't remember selling fentanyl specifically. He was selling Oxy or Roxy and not fentanyl. So does she get out now? Because he sold things to Carmen, but he thought the things were different, I guess. So that was the basis of the defense motion. The court is going to give their denial. Kouri is still in custody with no bail. Before the court is defendant Kouri Richins' second motion to reconsider bail and conditions of release, through which the defendant requests that the court reconsider its previous detention ruling and grant her the privilege of pretrial release. Under Utah Code, section cited, defendant may move to modify the court's pretrial detention order only upon a showing where there has been a material change in circumstances. Your Honor, you're going to take the easy road, aren't you, Your Honor? You're going to just be like, this motion is not appropriate at this time because there's been no change in circumstances. I think that's where we're going with this. Defendant asserts that there has been a material change in circumstances because recent statements by one of the state's witnesses, Mr. Crozier, changes the landscape to a degree that cannot be ignored. Specifically, defendant asserts Mr. Crozier's recent recantation of his prior statement that he sold pills containing fentanyl to Miss Luber, that's Carmen, changes the evidentiary landscape in a way that precludes a finding of substantial evidence to support the charge of aggravated murder. It's a very stretchy reach. Substantial evidence standard, and then the court's going to go through the standard. We went through it multiple times about whether or not there is substantial evidence in the case. It's not just a one piece of evidence. So the court's going to go through that standard again and the case law on the standard and what it is. The court sets forth the standard. I like the court's writing, what the standard is, and then the relevant background, which is what I want to get to. On June 12th, 2023, the court took evidence. I can't believe it's been that long. The court took evidence and heard argument on the state's motion for pretrial detention. At the conclusion of the hearing, ruling from the bench, which we love, the court determined substantial evidence supported the charge of aggravated murder because the court found that the evidence of means, motive, and consciousness of guilt considered as a whole could permit a reasonable jury to conclude that the defendant committed the charged offense. The court specifically referenced, among other things, evidence that it considered the following: evidence showing Eric Richins died of fentanyl ingestion, evidence showing defendant purchased 15 to 30 pills from Ms. Luber approximately 1 month prior to Eric's death, sworn testimony from Ms. Luber that she acquired fentanyl pills from a source and handed them to defendant in a hand-to-hand transaction in defendant's driveway. Footnote 1. According to Ms. Luber's 1102 statement in February 2022, Mr. Crozier told Ms. Luber that he could get her fentanyl, and on 2 occasions that month, she purchased from him what she believed to be fentanyl. And what was in the victim's system? Fentanyl, that's right. Evidence indicating that defendant's subjective understanding at the time of Eric Richins' death was that she would get a greater share of the marital estate if Eric died during the marriage than if he and the defendant had divorced. Evidence showing that in the months leading to Eric's death, defendant's personal and business bank accounts were overdrawn. She was making significant recurring debt service payments, and the lines of credit available to her were maxed out. Evidence showing that at the time of his death, Eric's life was insured in a substantial amount with defendant listed as the beneficiary on the policy. Evidence showing consciousness of guilt, including evidence regarding defendant's internet search history. Google's gonna get you. Internet search history in the aftermath of Eric's death, and evidence regarding the movement and manipulation of defendant's phone that is not consistent with her statements to first responders regarding what she and Eric did, or what she did before discovering Eric dead and calling 911. Footnote 2. Cognizant of the media attention this case garners and the fact that jury selection begins in less than 3 months, the court's summary of this body of evidence, which was discussed in detail on the record at the detention hearing and preliminary hearing, is intentionally vague. Every time. On November 12th, 2024, the court heard argument on defendant's first motion to reconsider bail and conditions of release. Notably, defendant did not challenge the court's determination regarding substantial evidence to support the charge of aggravated murder. Rather, defendant argued that less restrictive conditions were reasonably available to ensure public safety and guard against defendant's risk of flight. The court denied defendant's motion for the record, or for the reasons stated on the record. But now, through her second motion to reconsider bail conditions of release, defendant does challenge the court's determination regarding substantial evidence. Specifically, defendant asserts that Mr. Crozier's recent recantation of his prior statement that he sold pills containing fentanyl to Ms. Luber changes the evidentiary landscape in a way that precludes a finding of substantial evidence to support the charge of aggravated murder. The parties' briefing shows some ambiguity has arisen regarding Mr. Crozier's recollection of whether he sold fentanyl pills to Ms. Luber. Right. Was it fentanyl or was it like street oxy? You know what didn't change? He never said, no, I never sold pills to anybody. His belief of what the pills were is what changed. That's it. Okay. On May 4th, 2023, during an interview with Summit County detectives, Crozier confirmed that he sold fentanyl to Ms. Luber. Further, he rejected the possibility that Ms. Luber asked for oxys or something like that and got fentanyl instead. On March 28, 2025, Crozier participated in a trial participation interview with Chief Prosecutor Brad Bloodworth and Chief Investigator Travis Hopper. Mr. Hopper remembers the following from that interaction. Mr. Bloodworth reviewed his outline summarizing the information obtained from May 2023 with Mr. Crozier. Mr. Crozier did not say that any part of the outline was false or misleading. That's new information. I wonder if that was the sealed part. Either way, Mr. Crozier did not say that any part of the outline was false or misleading. Mr. Crozier did state that he was unable to recall all the details because the events being discussed had occurred approximately 3 years earlier. Reasonable. In 2 affidavits signed on April 10th, 2025, Crozier tells a different story. So in March 2025, he didn't say it was wrong. He's like, my memory's gotten a little fuzzy. But then in September, he tells a different story. Crozier states that during the trial preparation interview with Mr. Bloodworth and Mr. Hopper, he told them that he was certain that he sold Carmen OxyContin 30 milligram pills, otherwise known as Roxy's or Roxy 30s. This is what he told the defense. Crozier explains that in early 2022, he knew the term, quote, blues to mean OxyContin. He asserts that he did not associate the term blues with fentanyl until late 2022. He asserts that he did not begin selling fentanyl until the end of 2022. Footnote 3. The court may properly consider Mr. Hopper's affidavit and his recollection of what Mr. Crozier said because the Utah rules of evidence, including rules regarding hearsay, do not apply to proceedings with respect to the release on bail or otherwise. It goes on to say, Crozier explains that he was very confused and very out of it when he interviewed in May 2023 because he was detoxing from drugs. Okay. Ruling. A party may move to amend a pretrial detention order only upon a showing that there has been a material change of circumstances. Defendant asserts that there was, based on Crozier's statements. The court goes on to summarize the defense argument thusly, saying specifically defendant argues that because Mr. Crozier now asserts that he sold only OxyContin to Ms. Luber, that he did not begin selling fentanyl till late 2022, there is insufficient evidence to permit a reasonable jury to find beyond a reasonable doubt that defendant was in possession of fentanyl in 2022 or that she could have used it to kill her husband. Therefore, defendant argues that there has been a material change in circumstances that requires the court to hold a detention hearing and determine conditions of defendant's release. Defendant's argument is unpersuasive for 3 reasons. Oh, only 3? Okay. First, a reasonable jury could choose to credit Mr. Crozier's statements to detectives in May 2023 over his statements in September 2025, given that they were made 2 years closer in time to the events in question. Especially if they're recorded and the jury can assess his demeanor. Indeed, if Mr. Crozier testifies consistent with his September 2025 affidavits, the state may impeach him with his prior statement that he sold fentanyl to Ms. Luber on 2 occasions in 2022. His retraction of his former statement does not render his former statement inadmissible. It's still evidence. Second, defendant fails to acknowledge or address. Correct. Second, defendant fails to acknowledge or address the other evidence from which a reasonable jury could find defendant had a motive to commit the crime charged and exhibited consciousness of guilt. Mr. Crozier's recent recantation, and I disagree with the framing of that, Mr. Crozier's recent statement does not affect the weight of that evidence at all. Period, Your Honor. Third, defendant's argument implicitly misunderstands. I agree. I yelled throughout the entirety of trying to cover the defense motion because I'm like, that's not how any of this works. Third, defendant's argument implicitly misunderstands the substantial evidence standards. In determining whether the state has shown substantial evidence to support the charge of aggravated murder, the court is not required to determine that a reasonable jury will, would, or is likely to convict defendant. Rather, the court's task is to decide whether the state has even in light of the defendant's contrary evidence, placed into the record evidence sufficient to permit a reasonable jury to conclude that the defendant committed the offense charged. Stated plainly, the court, did I stutter? Stated plainly, whether a reasonable jury could convict defendant of the charge. Right. Could a jury? While defendant may be able to use Mr. Crozier's recent recantation to poke holes in the state's case, the holes are not substantial enough to undermine the court's prior determination regarding substantial evidence. I couldn't agree more, Your Honor. Yes. It's giving we're trying, Your Honor. It's on the struggle bus with me and my microphone at the beginning of this stream. We're all on that struggle bus together today. The court goes on to say that in Randolph versus State, quote, poked holes do not demand the district court conclude that the substantial evidence standard has not been satisfied. The fact that a reasonable jury could choose to credit Crozier's statements to the detectives in May 2023 over his statement in September 2025, combined with the body of evidence showing motive and consciousness of guilt, is sufficient to permit a reasonable jury to conclude that the defendant committed the charged offense of aggravated murder. Accordingly, the court determines the defendant has failed to show a material change in circumstances. Accordingly, we're not hearing your motion. Get out. Yeet. Denied. The court respectfully denied, but denied. Get out. I really hope that the court has a physical stamp and not a digital stamp, because that stamp is kind of delightful. And just being able to just be like, whomp, and stamp it would be very satisfying. It's like, I have ruled, stamp. It's a nice big stamp. I like it. So yeah, Kouri Richins is still in custody. And the court was like, no. So you have to show a change in circumstance. You didn't show a change in circumstance. We're not even hearing this. Just denied. No change of circumstance, which I agree with. But it is the defense's job to shoot their shot. I don't know if this was a good use of their time. I don't know if this is, with how much there is in this case, I don't know if this was a good use of time or if this was client just being like, get me out of custody. I don't know. I don't know what prompted that. But when the defense is like, we don't have a ton of time, it's like, okay, then why are you wasting your time with this though? There is one more order that we had not gotten to from the court that indicates what is happening with the motion to compel. So the defense had asked the court to compel the prosecution to hand over everything they're obligated to hand over. And the prosecution went, yeah, obviously, we're going to turn over everything we're obligated to turn over. That, yes, those are just the rules. It was basically a motion, Your Honor, make the prosecution follow the rules. Okay. So we have the court's order. It's more in minute order format, less of a like full order and ruling as we saw in the last one. This is from December 4th. This is denying the motion to compel, docket 1037 without prejudice. The chat is just, Lyndon, this isn't Norfolk County Council. Janie, we're not the Norfolk DA's office. There's like, just back to back in the comments. I love it. Oh, chat, you guys are always hilarious. The kind of minute order from the court says, before the court is defendant's motion to compel. Oh, this is a different one. Withdraw what I previously said. This is the different motion to compel. This is the motion to compel regarding the sister. Okay, scratch everything I just said. There was an additional motion to compel regarding the victim's sister. This one goes to the sister. not the motion to follow the rules. Perfect. Before the court is defendant's motion to compel Kouri Richins-Benson to comply with subpoena, or SDT, subpoena ducis tecum, which requests an order requiring Katie to comply with the following portions of the subpoena. We went through this. Katie's lawyer responded and was like, what the fuck are you even on? That's my summary. So what are you even on? What are you sending? This is the one where this is the sister-in-law that Kouri was talking about in the walk the dog letter. I believe this is the sister-in-law that testified at the detention hearing. I need to go back and look at my notes. It's been a while. I have not done my trial refresh of my notes in this case, but they are trying to get all of the information from Katie. And the attorney was like, what are you doing? Katie's attorney. They asked for specifically all documentation in your possession or control showing the financial activities of the Eric Richins Living Trust dated November 3rd, 2020, from March 3rd, 2022 to present. Hi. Oh, Travis is back. That's why George is yelling. I was like, why is George hollering? Because Travis is back. Thank you for telling me you're home. I'm glad you're back. It was good? Good. We are on our last document. Bye, George. George is happier now that he's been picked up. He's like, pick me up. I'm waiting for the day that George just starts trying to leap onto Travis's back. So George is, I was wondering why, I was like, why is George coming in here yelling? Travis. It's Travis. That's how long we've been streaming. Travis got to his doctor appointment and got home. Well, dentist appointment and got home. So they wanted all of the trust documents and then copies of checks drawn out of your personal or business checking accounts made payable to any individuals connected in any way to the investigation or prosecution of Kouri Richins. I remember this. Defendant's motion to compel is denied without prejudice for two reasons. First, how do you think you're getting any of this evidence? Like, what rules allow you to have this? First, defendant has not complied with the requirement to meet and confer with opposing counsel in an effort to resolve this dispute without court action. God, I just love it when the court follows the rules. Thanks, Your Honor. Some judges are like, I know it said meet and confer, but here's my ruling. And some judges are like, no, go back and follow the rules. There is a process. There is a procedure. Just society has rules. Follow the rules. That's it. Follow the procedure. That's all. They're not suggestions. They're not guidelines. Stick to the fucking code. What are we doing? The defendant has not complied with the requirement to meet and confer. And then the court goes on and lists out the meet and confer. Counsel actually asked for sanctions over this, as I recall. Second, the categories of information described in paragraphs 5 and 6 of the subpoena quoted above, as currently drafted, are overly broad and unduly burdensome, which counsel also argued. The court acknowledges that within the extremely broad categories described in paragraph 5 and 6, there is likely some information that is reasonably within the proper scope of third-party discovery in a criminal matter. For example, the judge is going to tell us. Records showing whether, when, and how the trust or the sister-in-law, who is the trustee, has paid the state's retained expert witness. It seemed to me that the trust, this is what it seems to me from how everything went down in the detention hearing. It seemed to me that the estate hired a forensic accountant to figure out what was going on with the estate. Because remember, the prosecution did not charge her for a year, a little more than a year after the death. The estate was already underway. It seemed to me that we were full suspicious of what was going on with the estate. So the estate hired a forensic accountant to start unwinding things. And then the prosecution used that forensic accountant in their cases, they got closer to charging. They were a great expert, but I think the estate hired them because of that delay in charging. It became a state's witness, but was not originally a state's witness. So the paying a state's witness is not quite the accurate impression. The state was like, oh, somebody's already looked at this? Hi, can we use them too? Can we copy your work? Can I get a copy of that? Great. They might be using a different forensic accountant now to not have any commingling of information, but I don't know. So it was not oh my God, they're out here paying witnesses. No, they hired the witnesses, and then the state was like, can I get some too? Which makes sense because they had already done the work. Let's see. The court acknowledges that within the extremely broad categories, there might be some discovery, such as whether the trust paid the state's retained expert witnesses, such as Miss Carrington, Mr. Gabler, and the Throckmorton. How had I forgotten the Throckmorton of it all? It's just such a thunderstrucky type of last name. I'd forgotten how delighted I was by Throckmorton. That has probative value and is potentially impeachment evidence. Hi, George. Hi, Trav. You're not. You're good. You have an ADHD question. Can you text it to me so we don't side quest and I can finish this document? Oh, you're talking about what you want to practice on guitar? Bullet for My Valentine. Oh, Faint's really good, though. Maybe Faint. Okay. George, go with Travis. I mean, you can always go into the chat and put it up for a poll. You're good, Travis. Bye, hon. What do you mean if your amp's too loud? Okay, so I'll keep it down. Yes, please. Oh, I think he's going with Faint today. But all right. Throckmorton. Back to the Throckmorton. Let's see. Probative value, potential impeachment witnesses. Yes. Did the state's experts get paid by the estate, or did the estate pay the experts and the state copied their homework? Which is exactly what happened. It goes on to say, no, I can't get rid of these. They're so annoying. I'm sure they are very helpful in other contexts. Not this one, but I can't keep up with the updates on the tech. All right. The court goes on to say that the burden of producing that information, given its limited scope, is reasonable, but as currently drafted, paragraphs 5 and 6 go well beyond anything proportional to the needs of this case. Moreover, because defendant's counsel did not conduct a meet and confer with counsel for the trust or for Kouri Richins-Benson, the court does not have the benefit of counsel's discussions regarding whether the scope of paragraphs 5 and 6 may reasonably be narrowed. For those reasons, the court denies the defendant's motion to compel Kouri Richins-Benson to comply without prejudice. The court encourages defense counsel to conduct a good faith meet and confer with counsel for the trust and Ms. Richins-Benson to determine whether the scope of the information sought by defendant may reasonably be narrowed. Following that meet and confer, if a dispute regarding subpoena compliance persists, defendant may file a statement of discovery issues under Rule 37 of the Utah Rules of Civil Procedure. So the court's like, yeah, that's ridiculous. We're not doing all that. It's too much. But again, when it comes to the defense trying to insinuate that somehow the victim's trust paid state witnesses, the impression is so wrong. It's flipped. And if it's not flipped, then I guess we'll see it. But from everything we've seen in this case, it seems to me that they were the trust witnesses first and the state borrowed them. So that's how I see it. So let's try to summarize what we've gone through in the 4 hours today. In the 4 hours today, which is why my kid just keeps popping in, because we've lived a whole afternoon today. And I am definitely ready to go get some lunch. But let's go through what we've covered today. We're going to get to some questions. I am going to check on when we can cover and when we will have some video of these hearings. And then we will cover these hearings as well. Because the hearings coming up in the Kouri Richins murder case are going to cover some of the things we talked about today, like the walk the dog letter, and are also going to cover the motions in limine regarding different experts, if those experts are coming in, the scope of that expert testimony, what's going to happen with this mysterious orange notebook journal situation, and if that's coming in, what might be coming in. And we will learn more about the case over the course of those hearings as the parties work to figure out what evidentiary issues still exist or what evidentiary issues can be resolved by the court before jury selection begins. They've slated about 3 weeks for jury selection starting in February. I think we will see testimony start at the very end of February, beginning of May, beginning of March. And so this case is our next up for trial. We have a number of hearings that are going to happen before then. Tomorrow, there's also going to be an arraignment of Nick Reiner in Los Angeles. I did a whole podcast episode on that case before the winter break. That arraignment is going to go something like, you're charged with these charges. Do you now enter a plea? Not guilty. Bail is still set at no bail. Do we want to set a date for bail review or set a date for preliminary hearing? What date are we setting? That's what's going to happen there. It's going to probably be pretty quick and pretty brief and pretty, pretty normal. And then what else is going on this week? There are a couple other cases that are in court this week and next week. We will be going over the Murdaugh case soon because that case is coming up before the Supreme Court in South Carolina, and we will cover those oral arguments together. It's kind of hard if we have video. I don't know if we'll have audio only or video, but we'll cover those oral arguments together either way because it is a very interesting question legally, and I need the conclusion of what happens with all the courthouse Becky shit. I have to know. So that's early February before this case starts trial. So we've got some in-court dates. And then, of course, the Karen Reed hearing that was supposed to be today got put over to the very beginning of February. So when this hearing goes, when this hearing goes, we'll cover it there too. So finishing up on what we did today, because I sidetracked myself, we covered the latest Kouri Richins hearing as they were preparing for the 2 days of evidentiary hearings ahead of trial. We are waiting on decisions about the walk the dog letter and what will come in. I think it will be partly redacted and then will come in. And we covered some of the judge's rulings denying the defense's motions to compel. Katie, my brain just stopped on her hyphenated last name. Apologies. Kouri Richins-Benson, who is the executor of the estate and the victim's sister, the sister-in-law or former sister-in-law of the defendant. And the defense was trying to compel quite a lot of documents. The court's like, you need to narrow this down and you need to have a meet and confer. The court was silent on the question of sanctions that the civil attorney had asked for. We'll see if that goes anywhere else with the sanctions. Probably not, but hopefully they will meet and confer and then we'll see. We also saw the court denying Kouri Richins' really third attempt at being released from custody. And the court was like, there is not a change of circumstance here. Remember, the defense was arguing that one of the witnesses had retracted their whole statement and the entire prosecution case had collapsed like a fifth grade mission project made out of spaghetti. And well, that's not what happened at all, actually. It was that might be a change of statement. It might be memory has lapsed over time. We're just going to have to wait and see till we get to trial. And the court said, there's no change of circumstance here. I'm denying this motion. Kouri Richins remains in custody pending trial. And there's going to be a lot happening in this case as we get closer to trial. And there is still this really interesting question that came up in the hearing today about appointing an attorney for Kouri Richins' mother. The court said that the issue was moot. I don't know if that's because Kouri's mom has hired an attorney. I don't know if that's because Kouri's mom is going to testify, not testify, but there is still this lingering issue of whether or not Kouri Richins' mom is going to testify, if there's a Fifth Amendment privilege there, and if she has retained her own attorney. Because at one point, the defense had asked that she have counsel appointed for her. And it seems that that's not an issue that's going to happen at this point, or that's not an issue that's going to be taken up at this point. But why? I want to know what's going to happen. So we have lots of Kouri Richins to cover this week. I know there are other things that have gone on over the time that I was off. And don't worry, I will be doing my best to keep up on new things and other things, but I do try to stagger cases so they are closer in time to what's going on. So Murdaugh, I'm going to cover closer in time to when he's going to be back in front of the Supreme Court, just so it's in time as best we can. And since Kouri is this week, I thought it was helpful today, since we weren't going to be in court in Massachusetts, to circle back on all the things that we hadn't covered yet, because Kouri just had to wait. There were other women that were in trial, Kouri. You're not the only one. You'll have our full attention soon, but not just yet, because we have lots of other cases to cover. And don't forget to get the Law Nerd app, because if you get the Law Nerd app, you will stay in the loop when we are covering court live, when we are covering documents that can be, well, very dramatic, and when the schedule shifts around, and updates on cases that we're covering as they happen. That is where I send out notifications like, oh my God, this thing just happened in this case. That's where I keep you up to date. Let's get to questions. One of the cats has, George has left some fuzz. So let's get to questions real quick. I saw a number of you asking, when is the next stream? We'll be streaming tomorrow. I just don't know what time yet. All right, let's get to questions. A lot of you are asking about, and did ask earlier, about the Karen Read sidebars. We'll get to it. It is not the most pressing thing we have in court. We'll get to it. We have so much going on, and I really want to watch these hearings in the Richins case. So I wanted to get through all of the motions that we hadn't covered and the rulings that we hadn't covered. So we will get to that for sure. Let's see what else we have in questions. Law Nerds, the Baker household is starting to feel better. We're still just like, but yeah, we're starting to feel better. And Andrea said, the sidebars are TTT for days. I'm sure we will get to it. We don't always get to things with immediacy, but we do get to them. So it will be one of those things. I appreciate that the spoilers are not spoilers. They're just like, girl, you need to read them. We will. Don't worry. I try to make sure that everything gets kind of ordered in a way that makes sense. And there's a lot going on this week that we needed to get to just because of the hearings coming up. If there weren't hearings this week, maybe that we would have done that differently, but it's okay. We'll always get to it. And don't worry, I'll let you know. I know I want to cover things together with you guys too. I love live court. And I wanted to go through these before live court. I wasn't quite sure how I was going to do it. And then the hearing today just vanished. Shockart said, accepted spoilers in the form of girl. Yes. Girl, what? Fair. Because I have not, I'm sure it's been covered a ton. I have not gone through any of that yet. Breezy Girl 313, thank you so much for the gifted memberships. Lots of you guys gifted memberships. Welcome to all of our new members. We will be having 2 members only live this month. So it's a good month. It's a good month to be a member because we're gonna get there. Excuse me said, miss the official 60 on to 61 months, which is amazing. I see your glorious new badges. It's really fun to see everybody rolling out with their new badges in the members spaces in the chat. I see all of your members badges. It's great. Miss DLS, thank you for the 10 memberships. I know there are lots of other gifted memberships in here if I haven't grabbed them. Thank you guys. I appreciate it. Are we doing a members only soon? We absolutely are. I meant to sit down in calendar yesterday and was fighting with all my computer cables for hours. So it did not get done yesterday. But then I was like, oh, I'll have time in the morning. I'll have time in the morning to sit down because I'll be up to get the Zoom going for the Karen Reed hearing, and I'll be all ready to go and all the stuff. And then it was canceled. And then we're like, oh no, we're doing a totally different stream. Let me go grab the documents I've been meaning to grab while I was on break. And then I was sick and then ADHD. And then and then all of that, right? Sarah said, I binged Bon Appetit for 2 days. I'm in love. It's such a good show. It's so fun. I've really been enjoying it. And since I was like, I just need I need something fun to watch on TV. And it was mentioned to me. Somebody else was like, oh my God, I was watching this. And I was like, yes, that sounds amazing. And then as if my devices were listening to me, it just popped up on Netflix. And I was like, now is the time. Now is the time to sit down and watch Bon Appetit, Your Majesty. I have time. Hannah said, first time hearing the judge's voice. Damn. We love this case. I love this judge. I hate that he hates the media so much. Like, Your Honor, who hurt you? We'll yell at them. Like, I'm happy to yell at them for you. Who do we need to yell at so that you don't hate everything? Because Your Honor, this courtroom has run so well. The attorneys have worked well together, even though I will criticize some of the arguments because, that's what we're here to do. We're like, that's a reach, but that's the job. Everyone has done their job and has gotten along and gotten stuff done, and it's been really nice. So hopefully after the jury is seated, the judge will just take a deep breath and let it stream. Even if it streams on a few hour delay, we'll deal with it. Katie asked, how was your lemon loaf? Katie, funny about that is that my taste buds, since I got sick, are not quite right. So it was not correct. I think it probably turned out fine. My family's like, it turned out good, but I am still recovering. So it did not taste correct to me, which is a bummer. So I froze the rest of it to wait for a little bit. Bridget said, I finally get to hop on a live stream. I'm usually working. I'm at Harry Reid Airport. I swear the airport announcement voice sounds exactly like this judge. That's funny. That it might. That's fantastic. It's been a minute. But I'm going to have to listen the next time I come through your airport. I definitely will. So go fund me for the judge reading calming meditations. Judges aren't allowed to take monetary anything, but I think he has a very valid second career in just reading like sleep meditations. He would also be a great law school professor. I really enjoyed this judge quite a lot. Rachel asked Emily question, did LA ever have celebrity jurors? All the time. I don't know how other people deal with it. It depends on the celebrity. Truly. If it's someone who's going to be like a security issue, like if we are dealing with a mega celebrity or someone who's a mega celebrity, like of the moment, if it's going to cause more courthouse security issues, they would probably just remove the juror. Even if the person's just like, but I really want to be a juror. It's like, okay, but we don't have the security capacity to take care of it. Like this is too disruptive to the courthouse operation. But if it's not disruptive to the courthouse operation, they would just sit on a jury like any other juror. So it's going to depend on the level of disruption, because the sheriff's department dealing with courthouse security is already at bandwidth most of the time, and adding in and day out of someone who's a celebrity who might cause additional security concerns would be difficult, which is kind of a bummer if somebody really wanted to sit on a jury and couldn't, because people couldn't just be chill that they were there. It wouldn't be the other jurors. It would be media and what have you. It would be difficult. So that would be tough. But I guess it would just depend on how everybody was and who the celebrity is. So it really depends. Let's see. Thank you, ABC's Docket. We're going with green this year. We're embracing the fact that I generally do better. I love wearing black all the time, but the greens definitely do better for me, especially on camera. So lots of greens. Don't worry. I'll see how this one washes before I share it. I've only washed it once. I want to see how it does before I share that I like it and tell you. So likelihood of the letter being admitted as evidence. High likelihood that the walk the dog letter comes in with redactions. Minimal redactions, but redactions. I think there's a solid argument that it shouldn't be redacted, but I could see the court doing some redactions. Yeah, I think it's high likelihood that comes in. Motion to finish the book next members only stream. We might have to do it like choose your own adventure style. And then she goes to court, and Courthouse Becky sneaks her snacks. Courthouse Becky is the one that sneaks her the Crest White strips. Can just bring everybody together. Perfect. Casually Kiki said, my boss and I are listening together while we work, and we are howling with laughter at how much fun Emily is having reading this. The case is so heavy. This side quest of the case is so ridiculous. It's ridiculous. And it still boggles my mind that people walk around being like, oh, everyone will totally believe this. Like, can you imagine saying this shit with your whole chest and believing yourself? I can't. But I say that about Murdaugh. I said that about Girardi. Like, how are you believing your own shit? I don't know what that's like. How people are how they're just walking around being like, obviously it's amazing. No, it's not. No, it's not. The turn the book into a musical is such a great suggestion. Hello, 2026 with 2025 fuckery. 2026 is going to keep us busy. We have lots on the court docket for sure. All the names changing. Kobe Mitchell said, did you ever watch Jury Duty? I have it on my list of things I need to watch. It's a vibes thing. But yes, I have it on my list. I've heard it's amazing. On my list. Who said Becky? Courthouse Becky brings Kouri eggs that she can trade while she's in custody. Of course. And everyone just says, but not intentionally. And it's amazing. So my, hold on, I need to screenshot my software on my end is struggling a little bit. I don't know if YouTube is struggling a bit today, but stuff on my end is struggling a little bit today. So with all of it, Law Nerds, we got to some questions. We've had a very long stream. I definitely need to go get some lunch. I will let you know in the app what time we are going to cover the Richins hearing if we can. Otherwise, we might shift gears and cover some other things. It will just depend on what happens. So thank you for the flexibility. Make sure you have the Law Nerd app. Turn on, of course, the notifications here. We will have some flexibility in when we're going live. So it's just going to depend on how all of the puzzle pieces fall into place, which I need to go take care of. So it is definitely time for me to go take care of that and get ready for everything tomorrow. Law Nerds, you are the best. I missed you guys over break. I hope you had a good break. It's always needed to take a little bit of a minute to recalibrate. Maybe next time I won't be sick, but hey, it is what it is. You know, there's only so much we can do. Law Nerds, you were the best. I'm going to roll the outro. I will see you tomorrow. When tomorrow? Well, TBD, but it's going to be fine. So I'll see you tomorrow. Go get the app. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.